Ms. Federico, apologies. Can you say something one more time so I can hear it on my end?
Okay, how about now? Select another video camera in settings. My camera won't start.
I can hear you on my speaker over here. I have a traveling pool monitor, so.
I think it is. Crystal. Nope.
Can you all hear and see me?
Yes, I can see and hear you.
Great, thank you.
Testing. Testing. It
I
worked.
can hear you. I cannot see you anymore, though.
There.
Now I can hear and see you. Perfect.
Morning. Before we get started, let me just make sure my court reporter is here and ready and can hear me okay. Harriet?
I can hear you.
Okay,
Thank
great.
you.
Thank you. Now calling proceeding number 24A-0327E. Today is January 9th, 2025, and it is approximately 9:00 a.m. This is a fully remote evidentiary hearing that was scheduled by decision number R24-0683-I that was issued on September 23rd, 2024 in this proceeding. My name is Melody Mirbaba, and I am the administrative law judge who is assigned to hear this case. Just remind everybody that consistent with commission practice, this hearing, both the audio and the video are being webcast on the commission's website. It's also being recorded, and we have a court reporter taking down everything that's being said. To ensure that we get a clear record, I'm going to ask everyone to keep your microphones muted until it is your turn to speak. Why don't we start with entries of appearance? I'd like to hear from Public Service Company of Colorado, who I will call Public Service or the company moving forward.
Good morning, Your Honor. Matthew Larson, Wilkinson Barker Nauer, LLP, on behalf of Public Service. I would also like to enter the appearance of Sam Eisenberg and Lauren Caliendo, also with our firm, as well as Steve Denman from Public Service Company.
Good morning, everyone. All right, now I'd like to hear from Colorado Public Utilities Commission trial staff, who I will refer to as the trial staff.
Good morning, Your Honor. Good morning, Your Honor. Brian Krakis from the Attorney General's office. Along with me is my co-counsel, Justin Larson, on behalf of trial staff.
Good morning. And then I would like to hear from the Utility Consumer Advocate, who I will refer to as the UCA.
Good morning, Your Honor. Kate Crampton with the Office of the Attorney General on behalf of UCA. I am joined by my colleague, Tom Dixon, and Inga Watford.
Good morning. Okay, before we get started with the evidentiary portion of the hearing, I've got quite a list of preliminary matters to address. I will address my list first, and then I will check in with all of you to see if I've missed anything or if you have anything else we need to go over. So as I outlined in an email that I sent to the parties on Monday, January 6th, I am denying as moot the UCA's motion to file unlabeled exhibits that was filed on December 18th, 2024. I am granting the UCA's motion authorizing the filing of surrebuttal testimony that was filed on December 18th, 2024. As I noted in my email, Public Service and staff are going to be given the opportunity to present evidence responding to UCA's surrebuttal testimony and any attachments thereto. As necessary to facilitate this, Public Service and staff will be permitted additional time during the hearing to present testimony from their witnesses and to cross-examine the UCA's witness and to present any other evidence that they would like to present in response to surrebuttal testimony. I am also granting Public Service's unopposed motion to file amended hearing exhibit 102 Rev 2 that was filed on December 19th, 2024. I am denying the UCA's motion to compel disclosures that was filed on December 20th, 2024. I'll note that the same day I sent this email sharing these rulings with the parties, that the UCA filed a second motion to compel after receiving that email. And I am also denying that second motion to compel. So that's the one that was filed January 6th. All of these rulings will be explained in a written decision. Obviously, was not able to get that out before our hearing, but I will get one out that does explain all of those rulings. Okay, so next I want to turn to an overall advisement that I like to give when I've got a settlement agreement. So during the hearing, if a witness for a party to the settlement agreement in this case clarifies a provision of the agreement, I expect that any party to the settlement agreement will let me know whether they agree with such clarifications. And if nobody speaks up, I will construe that to mean that party agrees with any clarifications that are made during the hearing. So silence means you agree with any clarifications that are made throughout the course of the hearing. I assume that the witnesses are going to be called in the order that we've got listed on the joint cross-examination matrix, but I'm going to ask the parties in a moment to let me know if that has changed at all. I want to remind the parties that we have confidential and highly confidential exhibits in this case and information in this case. And so I'm going to count on any attorney who is questioning a witness about confidential or highly confidential matters to signal that type of questioning is coming so that we can move into a confidential or highly confidential session. In that case, we will be turning off the webcast. I also am going to encourage all the witnesses to speak up if they believe their answers will call for highly confidential or confidential information, and we are not in a confidential or highly confidential session. And that'd only be if counsel doesn't say anything and the witness may know their answer is going to go into that territory, and perhaps counsel did not know. The next thing I want to hear from the parties on is if are there any stipulations about the admission of any exhibits? I'll hear from public service first.
Thank you, Your Honor. With respect to the exhibits listed on hearing exhibit 500, there is a stipulation with respect to the admission of all exhibits on that list, with the exception of exhibit numbers 302 to 322, which are exhibits that I believe UCA intends to use in their cross-examination or potentially use in their cross-examination. So those can come in over the course of the examination is the agreement that we have with the parties.
Oh, hold on a second. Let me just make a note of this. I have a couple of follow-ups because I think we might need to exchange out some of the exhibits that are on this list, because I did notice that the UCA filed revised, I think, attachments to exhibits yesterday. And I don't know if the one that we have listed is not those exhibits. So the way that we do it from this list, just to be clear in this record, is that the list indicates the filing date and the filing party. And that is the version of that document that was filed on that date by that party is what gets admitted into evidence. So if there's a later version filed, that won't get in unless we correct that. So Mr. Dixon, can you help me figure out if we have anything on this list that we need to set aside and admit separately via box.com?
Yes, and good morning, Your Honor, and the parties. I would like to clarify by virtue of your email that we received at 2:52 in the afternoon of January 6th, we corrected hearing exhibit 318A as you requested and renumbered it exhibit 322, which is what is one of the additions to the amended advised witness exhibit list. So that's the one change, and that was the one required by your decision. We also added as hearing exhibit 321, the response to UCA discovery request 5-1, the subject of the motion to compel, which you just denied. But we added that response as part of our exhibits. So that's hearing exhibit 321. With respect to those changes, we filed this amended revised document so you would have one document and not have to go back to the other documents to determine what our witness and exhibit lists were as of January 6th when we filed it. So that was simply to give you a clear understanding. We don't need to refer to the earlier list that was provided by UCA. And to the extent we need to move this list or put it in the record, I will do so now, because I understand it's not on exhibit 500.
Right. Okay. So why don't I start with going through what's being admitted? But Mr. Dixon, can you clarify for me? So yesterday at the end of the day, there was another version of hearing exhibit 301, attachment CN-6 and attachment CN-6HC that was filed, and I think it was also titled Rev 1. That was filed yesterday. That's not on our list.
Yes,
So-
and let me explain that. Thank you, Your Honor. Mr. Eisenberg contacted us yesterday advising that they requested that exhibit be refiled, and we agreed to do so. So it was at the request of Mr. Eisenberg, and if he wants to explain what was going on, that's just fine.
Yeah, I am curious. Obviously I didn't really have time to do a line by line, but I did do a quick review, and they look like the same documents other than maybe marked slightly differently. Mr. Eisenberg, can you shed light on that?
I may be able to, Your
Okay.
Honor, and we can have Mr. Eisenberg come on too. We're in the same room, so I don't want to affect the audio. It was just it was a marking issue,
Yeah.
just to make clear that that document was highly confidential. That was the reason that we worked with the ECA to refile it. So just for clarity that the document is protected.
Okay, yeah, and for what it's worth, I think that was helpful. And frankly, the way that this was filed was done, the original versions of the documents were marked correctly, but the way they were titled in e-filings was not correct. It didn't include the actual title of how the document was marked. So the way that it was done yesterday is exactly how it's supposed to be done. The way that it's titled in e-filings, the way that it's titled on the document. And I'm wanting to tell you that to the UCA because I've seen numerous issues with some of your filings in this case. And I take a lot of time in my procedural orders to try to highlight, here are some examples of where there are some problems. And then we've got last minute exhibits. This is one of them where the titles don't include the information they're supposed to. So I don't know how else to get your attention moving forward. Please try to get these right. Hearing exhibits 300, attachment CN-1 through CN-4 are all wrong. None of them include the substantive title of that document, either in how it was marked or in how it was filed. We're not going to redo that right now. I'm highlighting some mistakes, and I'm also applauding the efforts yesterday. That was done exactly right. Please try to do what you did yesterday moving forward so we don't have to continue to go through this.
Thank you, Your Honor. Just for the record, Ms. Watford is the paralegal that works on our cases, and that's why I asked her to be on this link, so that to the extent you had any concerns about what she filed and how she filed it, that she can make those corrections for you. So we will take that into account and do whatever is necessary to meet your goals.
Yeah, well, what was done yesterday, that those filings were done exactly right. So if she helped you with those, I applaud that. And
Yes.
most of your other exhibits were also done right. But, you know, there are these 1, 2, 3, 4 that you guys just missed. So I'm only highlighting it as please, these are the kinds of things to watch for in the future. Okay, so based on what we just talked about, I am not admitting hearing exhibit 301, attachment CN-6 and attachment CN-6, highly confidential, as it's listed on our spreadsheet, which is hearing exhibit 500. So those are the versions of those exhibits that were filed December 18th. We're not admitting those. Instead, unless somebody corrects me, we are going to, once we get them from the UCA's box.com folder, we will admit the versions of those documents that were filed yesterday.
So just, Your Honor, just to make it clear, are you saying you're not admitting just CN-6, or are there others?
I think those are the only two that were, no, there's going to be another one, at least one other we're replacing. So I don't want to admit the wrong versions. None of them are being rejected outright.
So again, I'm just trying to be clear. So you've agreed to admit, I guess, 301 HC or C. I don't recall what off the top of my head it is.
I haven't done that yet. I just told you what I'm not admitting.
Okay.
I've told you that I am not admitting the versions of those two attachments that were filed on December 18th, 2024, and that are listed on our hearing spreadsheet, which is hearing exhibit 500. We're not admitting those two.
Thank
I
you.
haven't admitted the others because they have to come in via box, and that requires the UCA to have them ready. And we don't have to do that right at this minute, but we can get it done before we're done. I need to go through the things on the exhibit list that we're not admitting. That way we know what is and is not coming in that's on this list. And I can then clarify everything else. So we've already figured out we're not going to admit the exhibit filed by the UC on December 18th that was identified on our list as hearing exhibit 318A. And I think there's a general agreement we're not going to be admitting any of these 302 through 320 until cross-examination. But I just want it to be clear in the record, under no circumstances am I going to admit 318A, which the UCA indicated they've marked as, I believe, 322, and will be offering it at the appropriate time.
Thank you, Your Honor. We understand the 318A and has no objection to it not being admitted.
Okay. Let me just check in with our legal support, because I think my hearing room has got its hand up. So, Casey?
Yes, I think you just clarified what I was going to ask about 322, but I was also going to say the 301 CN6 and 301 CN6HC, the revision ones, they're already in box if you want to address those now, just letting you know.
Yeah, why not? Because, Mr. Larson did indicate that the parties agreed to the admission of those exhibits, even though that was just a minor updated version marked differently. So, I mean, if that's incorrect, you all can just let me know. But if we want to just get that done so that we know it's in, that's fine.
Yes, Your Honor, we do have a stipulation with respect to the 301 that was filed yesterday.
Okay.
I believe that exhibit may be in our hearing box if you wish to have us have it pulled up.
Okay, Casey, why don't we go ahead and get that pulled up?
Just the public one, right?
Yes, just the public one. You've got access to the highly confidential version, so that can be moved into the record, but I don't want to put that on the screen, obviously. Thank you.
So, Your Honor, we move the admission of this document and as you've requested, and asked to be admitted at this time.
There being no objection, hearing exhibit 301 attachment CN-6 Rev 1 and CN-6HC Rev 1 are admitted into evidence.
Thank you, Your Honor.
All right, let me just see if there's any others on this list that we're not admitting, and then I can make a clear record.
Your Honor, just for the record, UCA did not object to any of the documents on list 500 and sent that to the parties a couple of days ago, advising them of that fact.
Great. All right, I don't know that this is really worth the effort, but I just want to encourage the parties that not to duplicate exhibits and file the same exhibit more than once. We end up having more in the record, and sometimes that makes it harder to muddle through. There's at least one instance where that happened, but I don't know that it's really worth pulling the one that's a duplicate. But just for you all, for your information, hearing exhibit 305 appears to be the exact same document as hearing exhibit 301 attachment CN-5. That's just one duplicate that I found. Let's try to avoid duplicates in the future, but I don't know that it's worth bothering with at this point. It's already on. And the UCA is going to be moving to admit those discovery responses when the time comes. And I think we're actually about to admit it in another version. If you want to confirm that, you can, but to me, they look like the exact same document. Mr. Dixon?
I just want to point out, We know that there were attachments in the surrebuttal testimony that were duplicates of other, but because we did not, because the company objected to the surrebuttal, because the company objected to the motions to compel, we intentionally included it because if the surrebuttal testimony had been denied, we had it under the general proposition where we had sent it out earlier. So we can clarify, our intent was not to duplicate, but our intent was to make sure that if the surrebuttal request had been denied and the attachments to that request were therefore no longer allowed, we included them in as a general, as you said, 301, for example. So that was our goal, not to be confusing. I agree with you very much that I don't like to see duplicate exhibits filed, not only within a party's filing, but between parties. So to the extent we can avoid that, that's always efficient and helpful.
I really appreciate that explanation, Mr. Dixon. That makes a lot of sense to me. So thank you for that. Okay. All right. I know I've been nitpicking a little bit this morning on this sort of stuff, but overall, I mean, the parties did a really good job with their exhibit. So let me just run through what's been admitted now. I think that covers all the ones that I had questions about. So with reference to hearing exhibit 500, which is our spreadsheet, we are admitting everything that is listed except for the versions of hearing exhibit 301 attachment C and 6, both public and highly confidential, that were filed on December 18th. And we are also not admitting at this time hearing exhibits 302 to 320, which will be addressed during witness examination. I have also admitted via box.com this morning, hearing exhibit 301, attachment CN-6 Rev 1, and attachment CN-6HC Rev 1. And to also just make sure we've got a clear record, this list details both the date and the filing party, so that's very clear in the record which document from the administrative record is being admitted into evidence. And we are admitting the most recent version of any hearing exhibit that has been filed. And I will just let you all know throughout the course of the hearing, I may be referring to a version of testimony that's Rev 2 or Rev 3. I'm going to drop the revision version, and it should be known we are referring to the version that's been admitted into evidence. Okay, so are there any questions about the exhibits that have been admitted into evidence?
Your Honor, I just want to clarify, if I may. I'm sorry. So 301 has been admitted. The one that was revised and we just did a few minutes ago, that was at Public Services request to be relabeled. Am I correct?
Both hearing exhibit 301 and the attachments thereto, including the two that we just got into evidence via box.com.
All right. And then 321 and 322 have not been addressed, and we'll deal with those on cross. Is that my understanding?
Yes, alongside with hearing exhibits 302 through 320.
Right. I just wanted to clarify those last two ones. Thank you.
Sure. Okay. Did anybody, I think somebody else might have had something they wanted to add.
No, all of the admissions are consistent with our stipulation. No additions from public service, Your Honor.
Great. Go back to my notes. Okay, are there any other preliminary matters that I should address before we get started on the evidence?
Just one thing from staff, Your Honor. If you look at the cross-examination matrix, I just note that no one has reserved any time on staff. We have a witness available if Your Honor has questions about the settlement agreement. I'm wondering if it might make sense if Your Honor has questions for staff to do those first, and then staff and our witness could be excused while UCA and PSCO elicit evidence on the dispute that staff has taken no position on.
I have questions for staff. And frankly, counsel, I'm surprised that you're not asking to revise your plan here today, seeing how I very explicitly indicated that I'm going to give staff and public service an opportunity to respond to Sir rebuttal. So it's obviously staff's choice whether you if you don't want to respond to the Sir rebuttal, but I definitely have questions for staff. And frankly, those questions might touch upon some of the other witness testimony. So in terms of excusing your witness to not hear what's happening, it's probably not a great idea. I mean, I'm going to let you do that at your own risk. But
No, that's fine, Your Honor. If you'd like our witness to stay, if you'd like staff to stay, that's fine. I just wanted to give you the option. I would note in your order on allowing staff to respond to the Sir rebuttal testimony, the Sir rebuttal testimony is on a dispute that staff has taken no position on. So we will not be eliciting anything on that and have no response to it.
okay, thank you for that. Mr. Dixon? You're muted.
Sorry, I apologize. In the effort to make this efficient, I just want to make it clear. While it is noted that the UCA objects to the settlement agreement, the UCA does not object to the provisions that are contained in the settlement agreement. The UCA objects to the fact that the settlement agreement includes no, disallowances. So I don't want to suggest that we oppose the terms of the settlement agreement. It was the absence of the disallowance that we requested that caused us to oppose the settlement agreement as a whole. So I want to make it clear for the benefit of you and staff and the company. We're not challenging that settlement agreement. It's just the absence of the disallowance provision, which is our sole issue left in this case. Also, with respect to the cross-examination exhibit witness, we're going to shorten our cross-examination, and I'm going to I'll properly not use the name properly. Let me get the test. I guess it Tetrault, Tetrault. We're only going to need about 5 minutes with him. We have a discovery response and a single question, so that'll be very short. With respect to Mr. Hansen, I believe, and I can confirm with Ms. Crampton, that we have waived cross on Mr. Hansen. Is that correct now? And she's nodding her head yes, for the record. And Your Honor,
Sorry, that is correct. We'll waive on Mr. Hansen, and I communicated that to the company yesterday.
right. So what I also want to point out, the time that we reserve for those two, we request be available in the event we go over the times planned for Ms. McCone or Mr. Schultz, given all the activity in here and the fact that our witness list and times were done largely before the motions to compel were addressed and things of that nature. We just simply request some relief should we go over based on the fact that we're eliminating lengthy questioning for those two witnesses.
Yeah,
Thank
and
you.
I'll just say that I expected to hear from everybody with some revisions on these estimates, because I do think it's a very big change that I am allowing, more testimony, more evidence to be presented based upon the Sir rebuttal. So I'm absolutely willing to be flexible, and I really think we've got plenty of time. I mean, we've got 2 days set aside for this, so I don't really plan on restricting and time limiting anyone unless we really start to get tight. Mr.
Thank
Larson?
you. Thank you, Your Honor.
Thank you, Your Honor. I just had 2 items. I believe with the UCA's revisions that they just discussed to the cross matrix, public service company witness Mr. Hansen, Mr. Knight, and Mr. Ryan all do not have any cross-examination time. If you have questions for them right now, wanted to check on that. Alternatively, if we need to address their excusal later, we could do that as well, but I wanted to raise that as a preliminary item.
So right now, I might have one question for Mr. Hansen, but my plan was to ask Mr. Schultz first. And that way, if he can answer it, then I don't need to ask Mr. Hansen the question. So it might be helpful to let's get through your first witnesses before we excuse Mr. Hansen. As to your remaining witnesses for which nobody has identified any cross-examination time, I don't have questions at this point for them. One thing I'll just advise is that from time to time, I might ask another of your witness a question I think they might be able to answer, and turns out they can't. So it is sometimes helpful for other witnesses to be ready to go if that happens.
Understood. Thank you. So we can let Mr. Ryan and Mr. Knight know that you don't have questions, but we will be monitoring and have them monitoring in case they do need to come on.
Yeah, and we can revisit that once we finish Mr. Schultz's testimony.
Excellent. Thank you. The only other item, and I don't know if you want to address this now, but in light of the admission of the SIR rebuttal, we do intend to conduct a short live direct examination of Mr. Schultz. We were going to take that in order when Mr. Schultz came up into witness order. That's the first part. Maybe I'll stop there, see if that's okay with you. And then I have a second item related to that.
Yes, that's fine.
Okay, thank you. The second piece of that is there's a public portion of that examination, the live direct examination, as well as a highly confidential portion. We could do it as public direct examination, public cross-ex, highly confidential direct examination, highly confidential cross-examination, or just do the entirety of the live direct. Don't necessarily have to decide that now. I wanted to raise it as a preliminary matter to see if you had a preference.
I'm a little concerned that I like your idea, don't get me wrong. I haven't seen it done, and I'm a little bit concerned it might get choppy and it might really confuse things. I could see an objection being outside of the scope of the examination, and then there being confusion because we've gone back and forth so many times. So I think as of right now, we'll do the sort of the normal procedure that we do, and I'll just review that for everyone. For confidential information and testimony, we just everybody who is a party to the case is able to continue on in our session. We just get off the webcast. For highly confidential, I have to be sure I go back through. I believe all of the parties in our case do have access to the highly confidential. Is that right?
That's correct, Your Honor.
Okay, so that'll make it simpler when we go in. We don't have to kick anybody out. But I am going to count on public service to you can reconfirm, that who we have, it's okay to have on there. But again, we'll go into a highly confidential session, and I'll make a record of it so that the transcript should signal the start of the highly confidential and the end of the highly confidential. But I am going to count on everybody to let me know when we're starting and when we're getting near the end. And I'm also going to count on everybody to be very, very careful not to question the witness about the public things in confidential or highly confidential session, because that portion of the transcript, that whole portion will be designated as confidential and highly confidential, and it will hamstring everyone. So please be very, very mindful of that. Okay, is there anything else, Mr. Dixon?
Yes, I just want to bring up, this case has an inordinately amount of highly confidential data, both in spreadsheets as well as in testimony. The UCA has no objection to the witnesses in this case having copies of those documents in their presence while they're testifying. I know ordinarily the commission does not want them to have anything in front that is not available. But given the size, for example, Hearing Exhibit MGS-1, which is part of Hearing Exhibit 102, is what I'll call a spreadsheet that has over 100 columns, closer to 150 columns, and 8,760 rows. I have no idea how you will display this exhibit on the record when we're in a highly confidential session. And the public version does not identify what the topics are, nor what the dates are, which I think are public. But again, I'm not objecting to it. I'm just saying we're going to be dealing with an exhibit that is inordinately huge. And I'm not sure how that can be displayed. So I want to point that out. And more importantly, I want the witnesses to be able to refer to what they have in front of them, as opposed to trying to follow it on the screen when it's this exhibit, for example, is a good example of something that I just don't think is going to be very visible on the screen. So I bring that to your attention, and I just wanted to, again, with the idea of maybe making it easier for this hearing to be conducted.
Well, in terms of that specific document, I think we have to cross that bridge when we come to it. I have no idea for what purpose it would even need to be displayed. There's just no way to answer that question right now, but I usually do advise the witnesses they're not allowed to look at any materials in front of them unless they are authorized to do so. But if all the parties agree that the witness should be permitted to look at either paper copies they have or on their own screen, I'm perfectly fine to allow the witnesses to do that if that makes it easier. What I'm going to advise the witnesses, though, is that they need to tell me or the attorney when they're going to do that so that we've got a clear record of what they're looking at so that we can all follow along. If that can help us avoid going into confidential and highly confidential session, I think that would be great. If all you need is for the witness to look at the document, but you don't need to ask them specific enough questions that get into the confidential and highly confidential, that this would work well. Is everybody on board with this approach?
No objection from public service.
None from staff either, Your Honor.
And none from UCA since I think I proposed it.
Yeah. Okay. All right. I appreciate the attention to the practical issues. In a case like this, the transcript is it can be very difficult, especially for me trying to write a decision and all of you trying to write your statements of position and ultimately the commission. We like to try to keep everything as public as we can. All right. With that, are there any other preliminary matters before we get started with the evidence?
Nothing further from the company.
All right, thank you. Public Service can call its first witness.
And Ms. Caliendo is going to be presenting Ms. McCone, Your Honor. So we're going to do a brief switch on the audio here. Thank you.
Public Service calls Marcy McCone.
All right, good morning, Ms. McCone. Please raise your right hand with me. Do you swear or affirm the testimony you will give in this case will be the truth?
I do.
All right, thank you. You can go ahead and put your hand down. Apparently, Zoom decided I needed to use the raise the hand feature when I swore you in. Can you go ahead and state and spell your name for the record?
Marcy McCone, MarcyMcKoane.
All right, Ms. McCone, I want to give you a couple of advisements. You are not allowed to get help from anybody during the course of your testimony. And if you become aware during the course of your testimony that you may have to talk about information that's been designated confidential or highly confidential while we are in a public session, will you please let me know before you answer that question? I'm sure you heard a lot of what we just talked about. The attorneys are going to do their best to let us know before the question is asked, but if they miss it, please do let us know. And then you are permitted to review any of the exhibits in this case that you might have with you in person. I'm just going to ask, even if you're not directed to do so, but I am going to ask that you let us know when you are doing that. And if you are doing that to refresh your memory or at your own discretion versus when the attorney directs you. Most likely, you're only going to be looking at those when the attorney directs you. Do you understand these advisements?
Understand. Thank you.
Okay. You can, Ms. Caliendo, you can go ahead and begin your examination when you are ready.
Thank you. Good morning, Ms. McCone. By whom are you employed and in what capacity?
Public Service Company as Manager of Regulatory Administration.
And did you cause to be filed in this proceeding hearing exhibits 101, 107, and 111, which are your direct, rebuttal, and settlement testimonies, respectively?
Yes.
And do you have any corrections to your pre-filed testimonies?
No, I don't.
And if I asked you those same questions today, would your answers be the same?
Yes.
And as Ms. McCone's testimonies have already been admitted into the record, Ms. McCone is available for cross-examination.
Okay. Who will be doing cross-examination for the UCA?
Thank you, Your Honor. I will be doing Ms. McCone, and Ms. Crampton will be doing Mr. Schultz, and I will be doing Mr. Terrault.
All right, you can begin when you're ready.
Thank you very much. Good morning, Ms. McCone.
Good morning.
For the record, I'm Tom Dixon, and I am an attorney representing the Utility Consumer Advocate Office, and we've dealt with each other many times in many cases, correct?
That's correct.
All right. Just a quick question going back to your statement of qualifications, and I just want to clarify. As the manager of regulatory administration, you're responsible for directing project management of utility regulatory filings for public service before the Public Utilities Commission of Colorado. Am I correct? I'm reading off of your statement of qualifications at the bottom. There's no numbering, but that's what I'm reading. Does that sound correct?
That's correct, with an emphasis on the electric utility for regulatory administration as opposed to policy.
And you manage resources necessary to make timely and complete regulatory filings, including support for the filing of a general rate case filings, correct?
That's correct.
And that would be what we term frequently as base rate case filings, am I right?
That's correct.
Yes. And then also it says certificates of need, which I don't need to discuss. And finally, rate rider filings, am I correct?
Yes.
And this case involving the ECA is a rate rider filing, am I correct?
That's correct.
And just for the record, I am going to try and avoid using acronyms. And I'm going to ask you, to the extent there is one, to actually identify what it means. So like I just referred to the ECA, my first question to you, what does ECA stand for?
Electric commodity adjustment.
And also this case involves the PCCA, am I correct?
That's correct.
And what does that acronym stand for?
Purchase capacity cost adjustment.
Okay. And those are the two riders we are discussing in this case, am I correct?
That's correct.
Okay. And those are the only two riders we're discussing, am I correct?
That's correct.
Okay, good. Just as we kind of discussed, normally the company's rates, and I'm talking baseline rates, are done in a general rate case, am I correct?
Yes, that's correct.
And the, what was again, ECA, electric cost adjustment?
Adjustment.
Yes, okay. Sometimes I've seen it as energy cost adjustment, so I want to be sure. The electric cost adjustment is a rider that was instituted for fuel cost adjustment purposes. Am I correct?
Yes, that's correct.
And the history of that is, that goes back to the 70s when there was energy issues going on and people were in gas lines and the like, that the commission granted a concept known as a fuel cost adjustment clause. Am I correct?
That's
you know.
my general understanding.
I've been around long enough, I know, back to 70s. So again, I'm not asking you to affirm the date. My point is, this clause was given to the company as a way to deal with what would normally be called volatile fuel costs, extensive, in other words, a significant amount of fuel costs, and costs that were beyond the company's control. This was a mechanism for you to recover these kind of costs without having to go through a base rate case. Am I correct?
That sounds reasonable, but I don't personally know what initiated that particular adjustment clause.
Okay, well, let's take it to the present. The present electric cost adjustment clause allows the company to, as you note in your application, I'll just use the term, to file and request recovery of fuel costs without going through a base rate case. And in exchange for that opportunity, you recover those costs if it's approved without receiving a rate of return, or sometimes called a profit. Am I correct?
I don't know what sort of return is involved in the ECA. Honestly, that might be a question for Mr. Knighton.
Okay, well, the point, I'm not trying to do something controversial. My understanding, and if someone wants to challenge it, fine, is that this is done with the company not earning any return on the fuel costs. I'm not talking about anything else in the electric cost adjustment, just on the fuel costs.
Again, I'm not quite sure if there is a return associated with the fuel costs in the ECA.
That's fine. I'm not going to push it. How much is the company, but by that I mean what revenue is the company seeking to recover as a result of the electric cost adjustment mechanism and the fuel cost that the company's incurred? How much?
For all of 2023?
Yes.
I don't know that number off the top of my head, but I think that Mr. Knighton sponsors that cost.
Well, we've waived costs on him. The goal was I thought we wouldn't have this issue. Is there a way you could give us that information at a later point in time?
Yes.
Okay. I mean, the alternative is, Your Honor, we could call Mr. Knightley to the stand and ask him the same question. My intent is just to get the magnitude of what is being requested here. So
I think it was around 750 million, but I'm speculating.
that's good enough. I'm not trying to have a pinpointed number. Thank you. Just for the benefit of the record, what is the PCCA, again, purchase? Go ahead.
It's capacity cost adjustment.
Yes. What does that recover?
That recovers our capacity costs, primarily through purchase power agreements.
And would those be purchase power agreements with what are known as independent power producers?
I think that's some of them. I don't know if that's all of them.
Good. I'm not trying to get the scope, just some sense of who in general. Now, as the case presently stands, Mr. Neal, on behalf of the UCA, is seeking a return or disallowances of 2.9 million of your approximate $750 million request. Am I correct?
Subject to check. That sounds about what I've heard.
Do you know Mr. Chris Neal, the witness in this case, in terms of in a professional sense?
I've worked with him on cases.
And can you tell me how long you've worked with Mr. Neal on cases in your tenure?
That I don't recall. I've been in regulatory since 2008. I don't know how long I've been dealing or working with Mr. Neal.
If I represent you, Mr. Neal started at about 2012, which is in his attached resume. Would you suggest you've been working with him since then, or in cases, or even in stakeholder meetings?
I think that's possible.
Okay. Have you reviewed his resume? It's about a 12-page document that was attached to his answer testimony. I think it's CN-1 of hearing exhibit. Let me get the number, 300.
No, I haven't.
Okay. Do you know anything about Mr. Neal's background in terms of his work experience or his experience concerning issues that are related to this case in particular?
I can't speak to his experience.
Do you attend stakeholder meetings that relate to the electric cost adjustment clause?
I do.
Do you recall if Mr. Neal has been at electricity cost adjustment clause meetings that you've attended?
Yes, I believe he has attended those meetings. I don't know that he's attended them all.
How many of these meetings would you believe that he has attended where you also were present?
Well, we have them quarterly. I don't know when that first started. I think it's been at least a couple of years. So
Would
maybe
you agree?
a couple of years.
Okay, sorry. Would you agree with me, Mr. Neal has raised issues similar to what he's raised in this case in stakeholder meetings?
What issues are you referring to exactly?
Just the very issues that he's raised in this case, the question of whether to dispatch combustion turbines, which are referred to as a CT, and at the same time to curtail renewable energy resources such as wind. Has he raised issues regarding this similar to what he's put in his testimony here today in stakeholder meetings?
I don't recall.
Okay.
But he may have. I just don't recall.
Just a matter, do you have a sense of how many meetings you may have been in, quarterly meetings where you've seen Mr. Neal appear?
Like I said, we've had quarterly meetings, I think at least over the last couple of years. So, I mean, I can't speak to exactly what that number is.
Would it like 8 to 10 times? Would that be an approximation? I'm not looking for an exact number. This is not a memory challenge.
Maybe. Yeah,
Okay.
that sounds reasonable.
Do you attend all of the ECA electric cost adjustment stakeholder meetings?
I have not attended them all, but I try to attend most of those meetings.
When Mr. Neal has been present, do you listen to what he has to say? And when you are present?
I mean, I listen to what everyone says in the stakeholder meeting.
Well, my question is whether you listen to Mr. Neal. That's all I'm asking.
Specifically, I'm sure I've heard him speak in those stakeholder meetings. But a lot of it is the company presenting information. I wouldn't say that stakeholders are presenting information. They mostly, raise questions about the information that we're presenting based on the input that we've gotten from them on what they'd like to talk about.
Mr. Dixon, are we going to get to something relevant? Whether she listens to Mr. Neal in meetings that you haven't even connected to anything specifically at issue in this case doesn't have any relevance.
Yes, Your Honor, I'm sorry to hear you feel that. Maybe once I go further, you'll have some different sense to it, but fine, I can move on. In your testimony, you point out that what Mr. Neal has provided is a simplest, and this is in your rebuttal testimony generally, that what Mr. Neal has done is provided a simplistic approach to addressing the issues in this case concerning his 90 citations or events that he discusses as answer testimony. Am I correct?
That's correct.
And in your testimony, your direct testimony on page 28, if you want to turn to that, and that is hearing exhibit 101, a direct testimony and attachment of Marcy McCone. Beginning on line 21 through I'm sorry, give me just a minute. I may have a bad line number. Let me pull up my copy. Your Honor, just give me a moment. I may have got a bad line number. I know what I want to ask. Well, let me ask you this. In your testimony, you describe, and I'm quoting, that normal activities common to a utility's safe and reliable electric operations are weather events, planned and unplanned transmission outages, planned, unplanned generation outages, and an increasingly part of clean energy transition in which the company has been a leader, as well as the continued integration of growing levels of weather-dependent clean energy. Am I correct?
What's your question?
If that what I just read to you is a correct statement of the normal activities common to a utilities providing safe and reliable service.
Yes, that's correct.
And further, you've also identified must-run designations as being a normal activity dealing with the utility safe and reliable electric operations. Am I correct?
Yes, that's correct.
Now, on page 11, you say numerous factors can impact the generation from a particular facility. And I'm talking now about your rebuttal testimony. I don't think we need to go there. It's just a general question. If you want, I'm certainly willing to bring it up.
I'm sorry, what was the question?
Yes, that numerous factors can impact the generation from a particular activity.
Yes, that's correct.
And when we talk about generation here are combustion turbines, correct?
That's one aspect of generation.
Yeah. I'm just trying to do with the two that are at issue by the UCA. And also wind generators, which have been subject to curtailment in your case. Am I correct? That's a generator. Yeah.
Right.
Okay. Now, with regard to these normal activities that I've just discussed, the company knows these normal activities and what's happening when it dispatches a generator, whether it be a combustion turbine or a wind turbine. Am I correct?
I mean, I can speak to that generally, but probably the best person to speak to is Mr. Schultz as to what his awareness is when they do that dispatch.
Okay, but would you agree with me that whoever Mr. Schultz talks about the process? Would you agree with me? Someone has to actually set what generation is going to be conducted, what's going to be used, taking into account these activities that I just used by example that you cited in your testimony. Some public service company employee or potentially contractor, if necessary, will be dispatching, taking these into account.
I mean, generally, yes, I would think that was true.
And so a person dispatching generation needs to know these normal activities that we just went through. Am I correct? In order to dispatch.
Yes, I mean, that's my general understanding, but again, I'm not in that organization. I don't know exactly what it is that they look at when they do their dispatching.
That's fine. I'm just talking in generalities. Ms. Crampton will deal with Mr. Schultz, but because you've raised these issues in your testimony, I don't want to walk away from you and find out I should have asked this, or she should have asked you. So just clarifying what's in your testimony. So at any time a generator is dispatched, these normal conditions will impact the dispatch and the decision of what generation should be performed or requested. Am I right?
That's my general understanding.
I want to turn a little bit to the curtailment issue now. You state in your direct testimony, and again, we can pull it up if you want to, I'm not trying to misquote anything, that curtailments are an active dialogue at the commission. Am I correct?
Subject to check. That sounds like what's in my testimony.
If you wish to look again, the goal is not to trick you. I'm on page 34 of hearing exhibit 101, and I'm looking at lines 8 through page 35, lines 5, to give you some background. Again, these are general questions, so I was kind of hoping we didn't have to go this far to speed up the process.
Are you waiting for an answer? I'm sorry, what was there?
I said beginning on page 34, line 8 through 35, line 5 is the area I'm discussing.
Okay.
And line 19 on page 34 is what I just read to you.
Got it. Thank you.
Thank you. And we might as well leave this up for a moment. You talk about that, again, we're talking about the stakeholders. What stakeholders have been engaged in this active dialogue you make reference to? And those what parties or what interveners?
I think UCA and staff have been involved in those meetings. I haven't been involved in all of those curtailment meetings because I think it is a broader scope than just the ECA. I think that the ERP is also involved, the electric resource plan. So I'm not sure what like the scope of all the stakeholders, but I know at a minimum, I think UCA and staff have been involved.
And I'm sorry, you said that an ERP, and I didn't hear you said that, what that stood for.
Electric resource plan.
And you describe in your testimony at length the whole history of the curtailments and all the things that have been raised. So I'm not going in there. But what I am trying to address, what issues have been raised in this active dialogue concerning curtailments that you refer to?
Right. I haven't been involved in all of those meetings, but I do think that generally the reasons for curtailments, why they're necessary, that's sort of the line of what's been discussed in those stakeholder meetings is my understanding.
And once again, how you said you've attended some of the stakeholder meetings on curtailment, but not all. Am I correct?
That's correct.
How many do you think you've attended?
I think I've attended one.
And with regard to, again, these meetings, was Mr. Neal involved in present during the one curtailment meeting you attended?
I don't recall.
Okay.
Who attended.
In your testimony on page 35, if we want to go to the next page, beginning on line 17, I believe. Let me make sure I'm correct. Yes. You state.
Hold on, for the record, I think if you could just refer to the hearing exhibit number so that we're clear what document we're looking at.
Yes, Your Honor. Sorry, I thought since it was up, that was covered. I'm again referring to your direct testimony hearing exhibit 101. I'm focusing on page 35, line 17.
Thank you, Mr. Dixon. And I just want to be clear, it's on the screen, but the screen won't be in our transcript.
I understand.
So, thanks.
Again, I'm trying to put it up for the convenience of the witness, and then I ask questions, which will be on the record. But I want to refer to this first line where you say on line 17, from time to time, curtailment has been mischaracterized as a problematic operations management tool, correct?
Correct.
What do you mean by that? Can you tell me what you mean by it's been mischaracterized?
I think maybe that there's been concern about the amount of curtailment on the system. I think it's a relatively new tool. I mean, I think we've done it in the past, but as more renewables are on the system, I think there's more curtailment.
Is there any other examples you can provide as to what were issues that led to a mischaracterization?
No, that's probably the only one I have in mind.
Maybe just for background.
Been part of all of those conversations.
Okay. Maybe for background purposes, when the company dispatches a combustion turbine, there are fuel costs associated with those combustion turbines, whether it's coal or gas or whatever. Am I correct?
That's correct.
And those costs are some of the $750 approximate $1 million costs you're seeking here in this proceeding, correct?
Yes, that's correct.
On the other hand, when people are concerned about the amount of curtailment and whether there's a sufficient amount, curtailment involves, in this case in particular, wind generators. Am I correct?
Yes, that's my understanding.
And wind generators have virtually, if not any, fuel costs. Am I correct?
That's my understanding.
So if a wind generator is dispatched instead of a combustion turbine, ratepayers are saving the costs of the dispatch of the combustion turbine, the fuel costs, and are not incurring any fuel costs for the wind generator. Am I correct?
Yes.
So when Mr. Neal reviewed highly confidential exhibit MGS-1, which is attached to hearing exhibit 102, the direct testimony of Mr. Schultz, and as an attachment to that direct testimony, that was what he was comparing. Am I not correct? Those are the 90 incidences that you and Mr. Schultz and others have referred to. Am I correct?
Yes, my understanding is he pulled that information out of that spreadsheet.
On these curtailments, did the independent power producers also participate in these stakeholder meetings?
No, they don't.
Okay.
I don't think so, no.
Okay. Now, in this case, again, focusing now on Mr. Neal's 90 events that were addressed, are these all company-owned wind generators that are being curtailed, if you know?
I believe so, but I haven't looked at each of those instances.
Would that be a better question for Mr. Schultz?
Yes.
Okay. in your, if we could turn and I'll pull up here in Exhibit 107, rebuttal testimony of Marcy McCone and attachments, and just pull up the document itself. I'll be going to page 8. And I'm going to be dealing with lines 8 through 16 and 16 through 19. So I guess 8 through 19, if you want to review that section before I ask you several questions. And just let me know when you're done.
Okay.
Lines 8 through 16 are basically your summary of Mr. Neal's challenges to the operation of combustion turbines while curtailing wind generators. Am I correct?
I'm sorry. Ask that question again.
The question is, this is a summary of Mr. Neal's answer testimony, and I'm saying, so this is your interpretation of his testimony on lines 8 through 16 as it relates to the dispatch of combustion turbines and the curtailment of wind generators. Am I correct?
Correct.
And then lines 16 through 19 is your discussion of, again, summarizing Mr. Neal's concern about operating custom turbines and pumping at the Cabin Creek generation facility. Am I correct?
Correct.
If we could go to page 14, lines 14 through 21. And again, if you want to tell me when you're done reading it.
I'm done.
Okay. Here you suggest that UCA is a disallowance request, which are really the requests of Mr. Neal. So I'll refer to Mr. Neal's requests, are based on a simplistic analysis that looks at certain conditions on the company's system, et cetera. I don't need to read the whole thing. Is that your understanding of your response to these recommendations?
Yes.
And if we go to page 15, line 9 to 10, here I'll just read it. You state the commission has made clear that this method of analysis does not meet the burden of an intervener to overcome the utility's presumption of prudence. Is that correct?
That's correct.
And then if we can go to page 16, line 1 to 2, you cite to an ALJ, which I believe is Judge Garvey, if I'm correct, states that at no time is safety or reliability of service or any other factor included or considered, and here he's talking about in the UCA's analysis. Am I correct?
Yes.
So he considered in this statement that the factors that may influence generation are necessary information the UCA has to present in order to potentially rebut the company's case. Am I correct?
That
In other words, we
needs to
failed.
provide evidence of imprudence.
Excuse me?
That he needs to provide evidence, of imprudence.
But the evidence are factors. The factors that we discussed earlier, which were called, I referred to as you referred to them as normal activities. These are the type of factors that we're supposed to include and discuss, according to the ALJ's quote that you put here, correct?
Correct.
Okay. And similarly, if we go to page 10, lines 14 to 16, and if you want to take a minute. Once again, you talk about the UCA or Mr. Neal's analysis as being a simplistic view of how the company system is operated and fails to demonstrate any imprudent actions on the part of the company, right?
Correct.
Again, we talked about normal activities, and here we're talking about factors, and I want to be sure those two things, the terminology slightly different, are meant to be the same thing from your perspective. Am I correct? As you understand Judge Garvey's decision that you cited.
Right.
Again, and let me help you. I'm going to give you a factor one at a time, and you can confirm whether this is what you think Judge Garvey was telling us to provide. A factor might be planned outages for any generators, correct?
Correct.
Another factor might be unplanned outages for any generator, correct?
Correct.
Another factor might be must-run designations that the company was aware of, correct?
Correct.
Another might be short-term procurements to address tight capacity, and I've taken that term from your testimony.
Correct.
Another might be curtailments managed by by WEIS SPP, and maybe you could spell out that acronym.
The Western Energy Imbalance. Western Energy Imbalance Service.
And SPP?
I might have that wrong.
And SPP?
Southwest Power Pool.
Okay. And so my question is curtailments managed by that organization, right?
Right.
Also, and this relates particularly to the wind generators, weather events impacting a weather-dependent generator. That's a factor. Am I correct?
Yes.
Also, pollution standards are a factor.
Yes.
And transmission operations or orders are a factor.
Yes.
And would there be environmental concerns like emissions reduction or the presence of emissions as a factor?
Yes.
Now, would you agree with me that windmills or wind generators, I'm thinking of back in the old days, wind generators don't have much of an emission issue or an environmental issue?
That's my understanding.
Yeah. Now, a combustion turbine, on the other hand, may produce, if it's run by coal, it may produce a social cost of carbon in its emissions.
I think that's possible, yes.
And if it's a gas turbine, we run the risk of a social cost of methane. Am I correct?
I think that's also possible, yes.
All right. If we could turn to discovery, I'd like to pull from our box here in Exhibit 303.
Mr. Dixon, I think I forgot to let everybody know that we would be taking a mid-morning break around 10:30. You're welcome to continue for another 15 minutes, but I just wanted to check in with you whether now would be a better time to break or if we should just proceed to 10:30.
We can break now if you'd prefer. It's whatever your preference is, Your Honor. I think I don't know if I can get done. I know my questions won't take 15 minutes. It's the answers that are a little longer.
Yeah, and I'm not rushing you to get done. Let's just go ahead. It seems like this might be a good breaking point before we pull up that exhibit. We'll take about a 17-minute recess, and we will be back in session at 10:30. I'll just remind you all that the webcast is going to continue, and that includes both the video and the audio, so be sure to mute yourselves. All right, we will be in recess.
All right, bye.
Good morning. Before we go back on the record, let me just check in with my court reporter. Harriet, are you there? You ready?
Yes, I am.
Okay, we'll go back on the record. Where we left off, Mr. Dixon, I think, was asking for an exhibit to be pulled up, but I'm going to have him remind us of that exhibit.
Yeah, let's go back to having her rebuttal testimony back up, and I want to go to page 16 of her rebuttal testimony here in Exhibit 107, the rebuttal testimony of Marcy McCone, an attachment. And I'd like to look at lines 3 through 6.
I'm there.
And here you point out basically the failure to analyze the factors which I just went through that go into the company's decision-making process is a fatal flaw, so to speak, in the UCA's testimony or case. Am I correct?
Yes, that is written in my testimony.
I'd like to turn to, like I mentioned earlier, let me just pull up another question. And with regard to that, please tell me whether the reports or documents that exist with the factors that we just discussed related to the hourly decision shown on Mr. Neal's table CN1 and CN2, and I'll represent CN1 is the CT, combustion turbine, and curtailment, and CN2 is the pump, the Cabin Creek pump storage and custom turbine table. That, again, repeat, please indicate whether these reports or documents could have been provided to the UCA. And I ask you that now.
What reports and documents are you asking about?
All the factors that we just discussed that you say are, here, again, please identify whether reports or documents exist with factors related to the hourly decision shown in table CN1 and CN2. That's the first question. Do they exist?
Your Honor, I'm going to object to this question. This is seeking the same information, asking the same questions that were the subject of the motion to compel.
And I'm just asking if they exist.
I think maybe just to start, Mr. Dixon, you're reading from a document. Can we get that identified and on the screen? That'll give me better context.
Well, yeah, I was happy to. It happens to be one of the exhibits that the company hasn't supported. So that's why I was going through this process.
Well,
Okay. Well,
okay.
I can do that. To expedite, I'm more than happy to do that. Could we go pull up here in exhibit UCA 303? And if you will take a moment to review that, Ms. McCone, I'll wait till you're done.
Let me know if you need me to scroll to the next page.
Yeah,
Or when
which
you
part,
need to.
do you want me to read it in its entirety, or is there something I should?
Yeah, you should read the whole page, because the discussion we just had about page 16, lines 3 to 9 is what this data response or this discovery response refers to, or question. So if you will take your time, please do so.
Okay, next page. Okay.
And this is the company's response to a question questions posed by the UCA and discovery set question. If we can go back to the top, I think it's 404-1. Am I correct?
That's correct.
And you are a co-sponsor of this exhibit. Is that correct?
Can you go back down?
Sure.
Yes,
To your knowledge, is the information contained in this document and your responses and objections in particular correct and accurate today?
yes.
Move for the admission of hearing exhibit 303.
Any objection?
Yes, Your Honor, would reiterate that this is again the subject of UCA's 2 motions to compel. I would also reiterate the objections reflected in the discovery response. That this request is argumentative, it seeks a legal conclusion. It is beyond the scope of Ms. McCone's testimony. Ms. McCone's testimony does not speak to UCA's litigation strategy or what they can or cannot do with the materials that the company provided to them.
Objection overruled. Hearing exhibit 303 is admitted into evidence. You did object to, I think, a question. I don't know if that question is even still pending. Mr. Dixon, did you have other questions about this document?
Let me just double check my questions and be sure. I think I could be done with it, but thank you for asking. No further questions that she needs to refer to it. I think we've got what we want on this one in. Thank you, and you can pull it down. In the end, in that response, you did not provide any documents or reports with the factors that you have related and described that we discussed before the break. Am I correct?
All of that information is in MSG 1, the attachment to Mr. Schultz's testimony. There is a lot of information provided there on operations.
And tell me again,
Those
what was that?
particular hours.
I'm sorry, what exhibit number?
I don't know what exhibit number that is, but it's attachment MSG 1 to Mr. Schultz's direct testimony.
And that, just to make it clear, we don't want to pull up the public version, and I'm not going to go into the confidential at the moment. We're talking about the spreadsheet I spoke of this morning that has 8,760 rows and over 100 columns that is marked highly confidential.
That's correct. That it has all of the detail around hourly operations.
And so if I look at that exhibit, I will be able to tell why, and let's just take the 90, and I'm not going to go through them. I'm just using it as an example. If I took one of the 90 that hasn't been discussed by the company in its response to hearing question 4.3 that was provided by public service, with the remaining ones, let's say the remaining 80, you're telling me that if I look at that document, I will be able to tell when a combustion turbine was dispatched and will know that it wasn't in testing. I will know it was dispatched. It wasn't dispatched because of environmental issues or any of those factors I identified. You're telling me that exhibit has a key that shows that?
Objection, Your Honor. That attachment Mr. Dixon is referencing is for Mr. Schultz's testimony. Ms. McCone cannot speak to that attachment.
Overruled.
I don't
Hold
dispute.
on.
Oh, sorry.
Let me just rule. I'm going to overrule the objection. Ms. McCone is the one that brought this up in answer to Mr. Dixon's question. So if she couldn't speak to it, she wouldn't have referred to it in answering Mr. Dixon's question.
And Ms. McCone, I'm not trying to trick you. If you don't know, that's fine. And we will call Mr. Schultz. But you're saying this is in this document, and I'm asking you where or how.
Well, it has a vast amount of information on the specific information that's included. That probably is a better question for Mr. Schultz.
Okay, that's good. Now, it's the company's position, and you espoused it yourself, I believe, that the mere filing of this case by the company, its answer testimony, its attachments, etc., its direct case alone, that filing in your testimony, that creates a presumption of prudence that shifts the burden of proof to the UCA to then rebut all that direct case. Am I correct?
That's my understanding, yes.
And so it's your position that if we didn't do anything else, and had not appeared in this case, that your direct case alone would be sufficient to prove the prudency of your activities in the electric cost adjustment fuel clause to
Well,
recover the fuel
or would
cost.
the other opportunities for parties to intervene in the proceeding and ask questions about the company's direct case. And if they put on evidence of imprudence, then we would respond to that.
Okay. Could we pull up here in Exhibit 304 from the UCA's box? And now, just before we start on it, I'm referring to the reference we talked earlier before the break. You talked about the company, the UCA's fatal flaw in its case. And so this question, this discovery response may have some relevance to that. So I would like you to take a look at hearing Exhibit 304 first. And please scroll slowly so Ms. McCone can read the entire document.
Let me know when you need me to turn the page.
Will do, thank you. Okay, next page. Okay,
First of all, you are a co-sponsor of this response in hearing Exhibit 304, am I correct?
that's correct.
Is the information contained in this document, to your knowledge, still accurate and correct?
Yes.
Move to admit hearing Exhibit 304.
Objections?
No objection.
Hearing exhibit 304 is admitted into evidence.
So if we really go to the last paragraph of this document, the last paragraph, the statement is, and I'll read it in the record, because the UCA did not meet its burden to prove imprudence, the company did not need to offer any additional evidence of prudence. Am I correct?
Yes.
Okay. And all the information contained in this is still correct, as we said, correct?
Yes, that's correct. I would also add that the company provided analysis around 8 of these instances.
I'm sorry?
I said I would also add that the company provided analysis around 8 of the 90 instances.
Right.
In addition to rebuttal testimony.
And just so it's clear, you're not the witness to address that. Am I correct?
That's correct.
Okay, that would be a response to hearing exhibit. I'm sorry, well, it's marked as hearing exhibit 305. We don't have to pull it up. That'll come up later, but you're talking about the response to UCA question 4-3 and the highly confidential document that was attached to that. Am I correct? Which I will reflect for the record is presently marked for identification as hearing exhibit 305.
I'll take your word for what the discovery request number and hearing exhibit number are, but yes, that sounds like what I'm referring to.
Thank you, Ms. McCone. I have nothing further, and I appreciate your answers. Have a good day.
Thank you. You too.
All right, I don't have any questions for this witness. Ms. Caliendo, any redirect?
Very briefly, Your Honor. If we could pull up hearing exhibit 101, specifically at page 11. Ms. McCone, on lines 4 to 5 there, you state that this section of testimony provides relevant background on the process and information of annual ECA and PCCA Prudence reviews. And then down below, on line 14, you state the evolving Prudence review presentation. You continue there, line 17 through 21, discussing the proceedings that have informed the company's filing in this direct case. and its ECA and PCCA annual prudence review, and the stakeholder discussions and various influences on the company's presentation of information in this proceeding. Do you recall your discussion with Mr. Dixon there briefly about the information the company provides in its ECA and PCCA annual prudence reviews?
Yes.
Can you provide some more information on what you mean there on how the ECA and PCC annual prudence review has evolved over time and the information that the company provides has evolved?
Can I pick up my testimony to just kind of run through that little section? Or do we want to look at it on the screen? I mean, I just wanted to kind of go through the various proceedings where we've added to this reporting.
Counsel, if you want to establish that your witness needs to refresh her recollection by reviewing that exhibit, you can go ahead and ask that question, and then we'll allow her to do that as long as there's no objection.
Okay, let's move then to page 12 at lines 3 to 4. Reference the 2019 Valmont and Manchief Settlement Agreement.
Okay, Ms. Caliendo, that's not how we do it. You have to establish the witness needs to review the document to refresh her recollection. So ask her that first, and then we can depending on her answer, then we can look at the document.
Okay. Ms. McCone, do you recall the various proceedings and settlement agreements that have informed the information provided in this ECA and PCCA annual prudence review?
I know them generally, which is why I wanted to just look through, if I can pull my testimony to refer back to it, that would be helpful.
Okay.
Excuse me, Your Honor, just to make this easy, we've stipulated all of this language being in the record already and have not objected to it, and I didn't ask any questions regarding it. So I would suggest it's probably unnecessary, but if you want it, it's fine with me.
Okay, I'm just gonna give Ms. Caliendo some leeway to ask what the questions are that she would like. But at this point, just to move us forward, let me just ask the witness. Ms. McCone, would reviewing your testimony and hearing Exhibit 101 refresh your recollection and aid you in your ability to answer the questions that Ms. Caliendo has just been posing?
Yes, it would.
Okay, you may go ahead and review hearing Exhibit 101. And Ms. Caliendo, if you can identify for the record, if you were going to direct her to certain portions of that way we have it in the record, what she's reviewing, and then you can ask your questions once she indicates she has finished reviewing that testimony.
Thank you, Your Honor. For the record, I'm referring to hearing Exhibit 101, page 11, line 3, through hearing Exhibit 101, page 21, line 2.
Okay.
Ms. McCone, as we were discussing earlier, you stated in your testimony that the ECA and PCCA annual prudence review has evolved over time. Can you explain that, what you mean by that?
Right. Over the past several years, through rate cases, through CPCNs, through ERPs, through stakeholder meetings with the UCA and staff, we've added a number of requirements through those settlement agreements and through discussions to put on a number of reporting requirements related to the ECA PCCA Prudence Review and quarterly reports. We've included unit level detail, must run detail, all sorts of hourly detail curtailments. This has probably been our biggest presentation to date, is this 2023 ECA PCCA Prudence Review.
Thank you. And do you recall your discussion with Mr. Dixon about the various factors that impact the generation dispatch?
Yes.
And some of those factors, including, as you mentioned, their must run. Did the company provide information regarding must runs in this proceeding?
Yes, we did. I believe that was attached to Mr. Ryan's direct testimony.
Thank you. Let me just review my notes. Nothing further, Your Honor.
Ms. McCone, thank you for your testimony. That will conclude your testimony for now.
Thank you.
So I'm going to turn to public service to call your next witness, and I'll just let everybody know at this point I'm planning for us to take a lunch recess right at noon for an hour. And then in the afternoon, we'll take another short recess, probably around 3 o'clock.
Your
So,
Honor.
Mr. Dixon, yes?
No, I'm sorry. During the break, I discovered there was a mistake on witness Exhibit 500. And I'm not suggesting we address it now, but I want to point out that on, I believe, December 18th, we filed a revision to hearing Exhibit 300, Mr. Neal's answer testimony, to put in some information that had come in late in discovery. So I want to know, I know that hasn't been admitted. I know it hasn't been offered. It will be when we deal with Mr. Neal, but it was not on hearing Exhibit 500. So I just wanted to point that out. That's our fault, but just to let you know. And I would hope that we can deal with that when we put Mr. Neal on a stand. And by the way, it was also objected to from the company that this particular revision was objected to.
Are you, just to be clear, are you referring to hearing Exhibit 300 Neal answer testimony, Rev 1?
Yes.
The public and the highly confidential version?
Right. Yes.
Okay. I want to see if I think my the person who created the spreadsheet has her hand up. Casey, can you speak to that? I mean, I'll just say what I'm looking at. I see it on here, and maybe I'm just not looking at the correct version, but I see that on here. Casey?
Yes, I do as well. I do as well. I was going to say I have revision 1 filed on 12/18 on the sheet.
Yeah, so do I, which means it's been admitted.
All right, thank you. That I apologize. For whatever, when I went back and looked at it, I didn't see it. Maybe my eyes are getting worse. I apologize.
That's okay.
Thank you.
All right. Is public service ready to call its next witness?
Yes, Your Honor.
All right, you may do so.
For the record, Sam Eisenberg, Wilkinson, Barker, Nauer. Very briefly, Your Honor, I agree with what was just said about the revision to 300, and that was part of the stipulation. Public service didn't have an objection to that, so I think that's covered. Public Service Company of Colorado calls Mr. Mark Schultz.
Good morning, Mr. Schultz. If you could raise your right hand with me. Do you swear or affirm that the testimony you will give in this case will be the truth?
I do.
Okay. You can put your hand down. Please state and spell your name for us.
Mark G. Schultz, MarkGschultz.
Okay, before we get started, I want to give you a couple of advisements, starting with any materials you might want to reference during your testimony. Please only look at materials when you're directed to or given permission to do so. And when that happens, you may look at any materials that you might have with you, whether that be paper copies or electronic copies. But for the most part, we will have exhibits also displayed on the screen. You also, during the course of your testimony, are not permitted to receive assistance from anybody on how to testify. And then finally, if you become aware during the course of your testimony that you may have to talk about confidential or highly confidential information when we're still in a public session, will you please let us know before you answer the question? Okay, do you understand and agree to comply with these requirements?
Yes, Your Honor.
Okay, thank you. And Mr. Eisenberg, you may start with this witness.
Thank you, Your Honor. Good morning, Mr. Schultz.
Good morning.
By whom are you employed and in what capacity?
I'm employed by a public service company, and I am the manager of power operations.
And you caused to be filed in this case your direct testimony, which is hearing Exhibit 102, and your rebuttal testimony, hearing Exhibit 108. And those have already been admitted into evidence. Is that correct?
Correct.
Your Honor, at this point, we would do the live direct of Mr. Schultz. I'll have a brief public session, and then we'll need to go into highly confidential session.
Okay, go ahead.
Mr. Schultz, in the So I'm going to ask you some questions relating to UCA witness Chris Neal's rebuttal testimony, which is hearing exhibit 301. You're familiar with that testimony?
I am.
And in the highly confidential session that we'll go to later, I'm going to ask you some questions about the specific events discussed in his rebuttal testimony. Just as background, there were 8 events that were discussed in Public Service Company's Discovery Attachment UCA 4-3.A1HC, which for the record is hearing exhibit 301, attachment CN6HC, revision 1. So that's just for the record, that's where we're headed. To begin, I want to ask you some general questions covering only public information about your review of Mr. Neal's rebuttal testimony.
Okay.
Mr. Schultz, after reviewing Mr. Neal's rebuttal testimony, did you conduct some additional review of those 8 events?
I did.
And did you find additional information about those events that would be helpful to the commission in understanding the assertions made in Mr. Neal's rebuttal testimony?
Yes.
And before we get into specific dates, can you discuss why, after reviewing the rebuttal testimony, you were able to find additional information in addition to what you provided in that discovery response that you sponsored on December 10th?
Yes, there were multiple reasons. I'll address a couple of them. First, in some cases, the issue at hand was not immediately clear to me when performing my first review, and I was not looking at particular hours and units that were of concern to the UCA. After going back and looking again, it was apparent that that these issues, each individual event, is complex and requires a thorough review of not just the units in question directly addressed by Mr. Neal, but also some of the hours that were hours and dispatch that was taking place at other units in adjacent periods. And the complexity of each event requires a layered review of all of that information. And I think we heard that there was a significant amount of data in my highly confidential attachment, and it takes time to review that much data and all of the decisions that would have led to the dispatch and the facts presented in that attachment.
Ms. Federico, if we could pull up the rebuttal testimony of Mr. Neal, the public version, which is hearing exhibit 301.
I'm going to object cautiously. I don't know where Mr. Eisenberg's going, but my understanding is this was direct examination on. Oh, I'm sorry. I thought he said answer testimony here in Exhibit 300, so I was going to object on those grounds, but this is 301. My apologies.
If we could go to page 10, please. We'll go to line 15 and 16. If we could just scroll up just a little bit for context. Okay, I'll represent to you that on line 5, there's a date listed. We'll do this one in public session without referencing the date. But on line 15 to 16, Mr. Neal states that Piesco does not explain why, and then there's a redacted name of a unit. We're also being run. And then he recommends a disallowance on that.
Yes.
I'm sorry, we may need to do this one in highly confidential session too. Could we scroll down a little bit? I apologize, Your Honor.
More, or should I keep going?
Yeah, I'm sorry. Just give me 1 moment.
Okay.
Okay, let's scroll back to page 10, please, just up to the top. Okay, on line 11 and 12, Mr. Neal states, however, wind generation was actually higher than projected, which resulted in wind curtailment. Do you see that?
Yes.
And is there anything else you would like to add about the difference in looking at what wind generation was projected on a certain day versus what wind generation actually turned out to be?
Yes, the dispatch activities and decision making is based on forecasted production, wind production. As we know, forecasts may or may not be in line with actual wind production on any given operating period. And in this particular instance, wind output was for an extended period above forecast. However, we are dispatching with the expectation that wind production is going to fall back in line with that short-term forecast. This is one of those events where production remained above forecast for an extended period. And those are challenging situations to dispatch through. The most prudent way to address those decision-making periods is to use the best information available. And in this particular case, that is the short-term forecast for wind production. And you can see how the period where wind exceeded production forecasts would have other impacts on the relative balance of generation and supply on the system. So we're trying to target a dispatch solution that incorporates the forecast information for forward-looking periods. Hopefully that helps address the concern.
Yes, could you also comment on the relative timescales of changes in wind output and the time it takes to make and implement commitment and dispatch decisions for the company's system?
Yes, wind production changes. It's a variable energy resource, sometimes referred to as a VER, and the production is constantly changing. It may or may not be in line with the forecast. Wind can move and change quite rapidly. Wind production can change quite rapidly on the system, and we are dispatching CTs and other generators around that observed production and that forecasted production. CTs, unlike a variable energy resource, have characteristics which limit the number of times you can commit and decommit them in a short period of time. And therefore, we are constantly looking at those real-world physical limitations that the CTs introduce to the decision-making process and balancing those against the forecast of that we're planning on from a forward-looking standpoint. For example, a CT once committed may have a minimum runtime. A CT once decommitted may have a minimum downtime. And if the expected wind production is forecasted to decrease in a forward-looking period, we don't want to bring on a CT that has a minimum runtime. And the flip side of that same case would be in play here. If wind production is expected to decrease, we would want to make sure that we have CTs online available to serve that generation that's expected to be needed at the time. Again, min runtime, min downtime are key factors for CT dispatch, and we are dispatching to the forecast.
And in discussing those dispatch events, could you just describe, can there be an overlap when you're dispatching a CT and the time the CT is on versus the time that wind is either online or curtailment? I guess the question I'm asking is those time periods don't always coincide exactly neatly. Is that fair as a first question?
Correct. I agree. There are dispatch decision making and reaction to fluctuations in variable energy resource output can be viewed as almost as a transition between periods of high renewable production or low renewable production. And these are decisions that need to be carefully considered, and you want to be certain that you are transitioning in the right direction. And therefore, to maintain adequate energy and reserves, you want to make that transition carefully and thoughtfully. It is often the case where you see brief overlap in periods where CTs might be running, and there could be some small amount of curtailment. And that plays into other relationships between these transition periods where we're bringing on thermal generation and then making the decision to decommit thermal generation.
Anything else you would like to add on that answer you just gave in relation to seasonality?
Yes, wind generation profiles and more importantly, as we add more solar generation profiles are changing. The amount of installed capacity on the system, the season of the year, the forecast for production, these are all factors that are taken into consideration in different ways, depending on the day of the year, the operating system, operating conditions present at that point in time. And these are factors that are constantly changing, is what I'd like to emphasize, I guess. The decision to decommit a generator, especially as I mentioned earlier, if there's a minimum downtime, can have consequences if you make that decision to decommit too early. For example, if we are entering a period where overall demand is declining, but renewable production is also expected to decline, therefore net demand, which we are serving with the thermal generators, is somewhat uncertain whether it will be incrementally increasing or decreasing during that transition period. We want to make sure that we don't decommit too early and put ourselves in a position where we're either energy or reserve deficient, or need to commit another generator, which carries costs, to correct for that early decommitment.
And you just mentioned the potential to be energy or reserve deficient on the system. Could you just briefly talk about some of the potential consequences if the company were to get into such a situation?
Yes, I mean,
Object to the form of this question. I think it's leading to the witness. I also think it's beyond the scope of Mr. Neal's rebuttal testimony.
Overruled.
the consequences of decommitting too early or ending up with insufficient generation online can carry both compliance and reliability consequences. In a worst case scenario, if the deficiency is severe enough, interruption to customers can take place. There are other NERC standards that I should say the NERC standards govern the amount of energy and reserves that need to be available at any given time for system balancing and maintaining sufficient reserves. If we find ourselves in violation of those NERC standards, there can be fines and other compliance implications.
And just one more question, if I might, in the public session, NERC, which you just referred to as the North American Electric, please.
Electric Reliability Corporation, yes.
Thank you. Your Honor, at this point, that concludes the public portion of this, and we would need to go into highly confidential session for the remaining questions.
Okay, we'll take a moment to do that. Casey, just let us know when we're ready, and I'll just ask that our court reporter make a note that we are about to go into highly confidential session.
Yes, I will do that. My only question is, I think you said at the beginning that you believed everybody who was on the call is okay to stay here. Just verifying that's accurate.
Yes, Mr. Eisenberg.
Yes, for public service.
Okay, Mr. Dixon, you've got your hand raised. I don't know if that's intentional. Did you have anything that you needed to say?
No, Your Honor, I thought I'd lowered it and just took care of that. Thank you. Sorry.
Okay. All right, then we are also, just so that you all know, I've got a couple of advisors that are going to join this session since it's not webcast.
That's what I was just going to ask about.
I knew that.
Back on. So just take a second. All righty, I think we are all set.
Okay, we'll go back into public session and proceeding number 24A-0327E. Ms. Crampton, you may continue your cross-examination of Mr. Schultz.
Thank you. And so Mr. Schultz, we talked about MGS 1 or MGS-1 HC and the volume of data points. And that was provided to the parties as part of your direct case, correct?
Correct.
Okay. And then let me back up. I think Mr. Eisenberg maybe asked you this, but just to clarify, you provided direct testimony and rebuttal testimony in this case, as well as the testimony here today, correct?
Correct.
And also, as part of your involvement in this case, you responded to several discovery inquiries from various parties, correct?
Correct.
Okay. And have you had the opportunity to also review the testimonies of your colleagues, in particular, your colleague, Mr. Treault?
Yes, I have briefly reviewed them. I'm not as familiar with their testimony as I am with my own, but yes.
Okay. Thank you. That's helpful. Okay. And so turning the discussion back to MGS1 and the volume of data points, I think you said something along the lines of you're sympathetic to the fact that it's kind of a difficult document to wade through. Is that fair to say?
Yes, I did say that.
Okay. And it's your understanding that what UCA witness Mr. Neal did is that he did wade through that document and he identified a number of instances that he thought were potentially imprudent because of the costs of running CTs and curtailing renewable energy at the same time, correct?
Correct. That's my understanding.
Okay. And then he also, it's your understanding, he waded through the document and identified instances of potential imprudence because of the costs of running CTs and pumping the Cabin Creek facility at the same time. Is that right?
That's my understanding, yes.
Okay. So those were the instances that you understood Mr. Neal had concerns about based on the data provided at MGS-1HC.
Yes.
And then you wrote, and he wrote answer testimony raising these concerns, correct?
That's my understanding, yes.
Okay, and you had a chance to review it and respond to it, largely responded to it in your rebuttal testimony.
Correct.
Okay. And in this answer testimony provided by Mr. Neal, he had identified these instances and believed that these instances could be representative of imprudence because of the costs associated with this type of dispatch. Is that right? Is that your understanding?
Objection calls for speculation as to what Mr. Neal believes. We can look at the testimony if there's a specific. I don't know what Mr. Neal believes when he wrote it.
I think she was asking what Mr. Schultz's interpretation was. So am I understanding that correctly, Ms. Crampton?
Yes.
So overruled.
So when I looked at the Mr. Neal's highly confidential attachment that outlined the events that were being questioned, there were comments regarding specific units that were of concern during those events. And that is where my initial focus was during my first round of research, was to address the concerns as I saw them pointed out in that attachment.
Okay. And we'll talk a little bit more about the 8 instances in the discovery response, but just generally speaking, Mr. Neal had raised issues of potential imprudence that you responded to in rebuttal, correct?
Correct. I apologize. I was clicking off of a computer restart prompt from Windows, and I think I have 7 hours left. So can you restate the question so I'm not distracted again?
Yes. Well, let me just, you had a chance to review Mr. Neal's analysis about the events that he was concerned about, correct?
Yes.
And you addressed them in your rebuttal.
Yes.
Okay. And his concern in his answer testimony was about potentially imprudent instances when CTs were running and renewables were being curtailed, correct?
Correct.
And the costs associated with that type of dispatch, correct?
Correct.
And likewise, he was concerned with Cabin Creek being pumped while CTs were also running and the cost associated with that type of dispatch.
Yes.
And those were concerns raised from the data provided at MGS-1HC.
Yes, that's my understanding.
Okay. And so then you responded in rebuttal testimony to this analysis, and you characterized this analysis as simple, correct?
Correct.
You state that the company's system is far more complex, correct?
Correct.
And that there is a full picture that UCA's analysis fails to capture.
Correct.
And by contrast, the company does have or understands the full picture behind its operating system, correct?
Correct.
Put differently, the information regarding the full picture of its operation system is within the company's possession or control.
Yes, I would point out that the decisions, there's a 24/7 team of experienced operators that are making these decisions based on hundreds, if not thousands of data points that come in every hour. And not all of those data points are or could be included in a highly confidential attachment like the one that was provided as part of this testimony. I, in my review as well, cannot put myself in the shoes of the operator who is digesting all of that information in the moment, which includes 4-second signals from the EMS about what regulation needs are, what renewable output, variable energy resource output is doing. There is far more information flowing through to the operator every minute of every operating day then could be provided in that spreadsheet. And my attempt here was to distill as much as possible the thousands of data points down to what is relevant and can help all parties understand why these decisions were made the way they were for each of those hours.
Okay. So it sounds like maybe not even you have all of the information that someone in an operating room might have, but that the company, and my question was, the company does have in its possession or control the quote unquote full picture.
I can describe a specific example that might help illustrate the complexity of the question you're asking and why there isn't a clear answer to that question. We have two operators on shift.
Well,
and-
let me
Okay.
hold on. Let me ask the questions
Like,
here.
I'd like the witness to be able to answer Ms. Crampton's questions.
I believe the response was non-responsive.
I think what he said was he couldn't answer the question. So for now, I'm going to overrule the objection. And Ms. Crampton, if you want to ask a different question, I do want to give the witness the leeway to, get to an actual answer.
Mr. Schultz, you were critical of the UCA for not having the full picture in its analysis, correct?
Correct.
You mentioned in your, I believe, direct testimony, you made reference to the 2019 ECA settlement agreement. Do you recall that part of your testimony?
Yes, I believe that part of the testimony addressed the requirement to provide some of this information that was filed as part of direct testimony.
Okay, and I asked you earlier about Mr. Treetall. Mr. Treetall also talks about prior proceedings that preceded this one, including the 2019 ECA settlement agreement. Do you recall that part of his testimony?
I do.
Okay, and one of the and that 2019 settlement agreement or proceeding resulted in a settlement agreement wherein the company agreed to reporting on certain aspects. Do you recall that?
I do.
So one of the aspects that the company agreed to report on was monthly curtailment costs for renewable resources under contract for PPAs.
Yes.
Monthly levels of curtailment impacts on production tax credits for owned renewable resources. Does that sound right?
Yes.
Monthly level of curtailment volumes with causation information based on actual curtailments, correct?
Correct.
And with respect to the causation information that was agreed to by the company as part of the settlement agreement, Mr. Treetall in his testimony sort of put in a footnote citing to your testimony, and in your direct testimony, you attempted to provide causation information in section 4 of your direct testimony. Is that correct?
I would have to look to the exact section, but yes, I'm familiar with what you're talking about.
Sure. If we could pull up hearing exhibit 102, I think the public version, page 23. And if we could scroll down. Yeah, just to this bottom Q&A. Thank you. Here, Mr. Schultz, you posed the question to yourself. Can you explain the cause of actual curtailments that occurred in 2023, correct?
Yes.
And then you indicate that the vast majority of curtailments in 2023 were required for system balancing,
Yes.
correct? And there's not, kind of going back to that discussion of MGS-1HC, there's not a code or a key for system balancing that's immediately apparent to the reviewer.
Correct.
Okay. And in your direct testimony, you do not, you give this amount the vast majority, but it's not otherwise quantified or given a percentage or numerical assignment for the number of curtailments that were for system balancing, correct?
Correct. Not in this section.
Okay. And system balancing, does that mean that the generation at that moment is more than the required load, or can you just describe that briefly?
Sure. It's bear with me because their system balancing is a broad category of specific reasons why curtailment is required. And system balancing can certainly apply to what you just described, where overall generation is greater than demand for a particular period. And that can happen as installed capacity is above what our lowest loads are on the system at times. That is not unexpected. It does happen. I will also refer back to the example I provided earlier today on missile site, where the point of interconnection has multiple projects on it, multiple gen ties feeding into a single point of interconnection. And in this case, that point of interconnection is the missile site substation. When the solution is to curtail one or more projects at a single point of interconnection, and there's freedom to choose which project is curtailed, then that is also classified as system balancing. And part of the background on why that's the case falls back to language in the PPAs regarding compensability of curtailments. So those are two examples. I'll stop there and see where you want to proceed from there.
Okay. Well, so if you have, I guess in this scenario, and the language you just used is escaping me because I'd like to use it back to you, but if I'm understanding correctly, if you have CT generation, or higher cost CT generation and wind generation that collectively will exceed the load, you either have to pay the wind generators to curtail load and keep the CT generation, or you could reduce the CT generation and keep the wind generation. Is that correct? Is that a system balancing type of decision?
I acknowledge that's the way Mr. Neal perceives those situations. The reality is they're not, that energy is not interchangeable. We can't simply decommit the CTs and allow the renewables to generate freely in these scenarios. And that is what I was trying to explain in some of the prior testimony and in the explanations to the 8 events that I analyzed. The generation is not interchangeable. And I acknowledge that from a cost perspective, it is not what we are seeking, but to the extent it can't be avoided because of reliability reasons, because of testing, because of any of the number of reasons that I outlined in my testimony, the rebuttal testimony, it carries cost, but it is not avoidable.
Okay. I think I understand. Mr. Schultz, did you hear the cross-examination or the testimony of Ms. McCone earlier this morning?
Yes.
Okay. And curtailments, you would agree that the issue of curtailments have been an issue of interest and concern for the commission and for stakeholders, correct?
Yes.
And in fact, in your rebuttal, in your testimony, you stated that that you understand that curtailments are both an area of interest for the commission and stakeholders, correct?
Yes.
And you heard Ms. McCone discuss that there have been stakeholder meetings to discuss curtailments.
Yes.
And have you been part of those stakeholder meetings to discuss curtailments?
Yes, I have participated in several of those meetings.
Okay. And the fact that that this is an area of interest and concern, as you wrote in your testimony for the commission and stakeholders, is because of the costs associated with curtailing renewables, correct?
I acknowledge that cost is one of the primary concerns. I don't know that it is the only concern. There are multiple parties that participate in those meetings, and I have heard a number of different concerns voiced.
Okay. One of the concerns, but there are many concerns about curtailments.
Yes.
And curtailments are very much part of the discussion here today in this proceeding as well, with respect to the issues raised by Mr. Neal in his answer testimony.
Yes.
And you identified that one of the costs or one of the concerns, one of many concerns regarding curtailments is that it costs money to curtail, just like it costs money to run the CTs, correct?
Yes.
And Mr. Schultz, are you familiar with the concept of economic dispatch?
Yes.
Just kind of briefly, what does economic dispatch mean to you?
Economic dispatch is the process of minimizing overall cost to customers by targeting a least cost dispatch plan. And and how that relates to curtailments is we are certainly targeting to minimize curtailments because we do recognize and acknowledge that curtailing renewable generation, especially on facilities that have production tax credits, and those tax credits require the company to reimburse the developer for those lost tax credits. Yes, we acknowledge that minimizing curtailment is part of economic dispatch.
Okay, and what Mr. Neal identified in his answer testimony were instances of potential imprudence related to an uneconomic dispatch of simultaneously running CTs and curtailing, or running CTs and pumping Cabin Creek, correct?
Correct.
Okay. And so he raised these issues from an economic dispatch perspective, correct?
Objection vague as to, I guess Mr. Schultz can answer the question. I just want to say that I think Mr. Schultz and Mr. Neal may have a different understanding of those two terms. So I want to make sure we're referring to what Mr. Schultz is testifying about.
Let me get that question clarified.
I just asked if the issues that Mr. Neal had raised were essentially from a claim of uneconomic dispatch, based on how Mr. Schultz has defined it.
I acknowledge that Mr. Neal's primary concern appears to be uneconomic dispatch.
Okay. And then in your rebuttal, you provide valid reasons, what you characterize as valid reasons that CTs might be run unrelated to economic dispatch, correct?
Yes.
And then in that discovery response that we've discussed previously in the highly confidential session, you applied some of those reasons from your rebuttal testimony to 8 identified instances of potential uneconomic dispatch identified by Mr. Neal, correct?
Yes, the primary instances that I outlined in rebuttal testimony before Mr. Neal identified those specific events were quite relevant to the events to explaining why curtailment and or pumping was taking place during periods of curtailment.
Mr. Schultz, I'm sorry, I have my volume all the way up, but I'm still having a little bit of a hard time hearing you.
I apologize. I'll try to speak up.
Thanks. And one of the things that, referring back to that 2019 settlement, one of the things that the company was to include was the cost of curtailments in its direct case, correct?
Yes. Sorry.
And the company in this instance did not actually provide that cost of curtailment in the direct case, but later provided it in a discovery response. Is that right?
Well, maybe Ms. Crampton could put the discovery response on the screen. That might be helpful.
Yes. If we could go to hearing exhibit, I think this is 302.
And I want to make sure that we're all on the same page with respect to what costs are being discussed, because there were multiple areas in which cost of curtailment has been discussed through this proceeding. I want to make sure I'm on the same page with everyone else when it comes to which specific costs.
Why don't you just re-ask the question now that we've got this exhibit
Yeah.
up?
I'm double checking, but this may be something that is highly confidential, the response.
There is the public version is what we have on the screen, and there is, I believe, just a confidential, not highly confidential version. Can we work off of, why don't you take a look at the public version and see if you can ask your questions using that? If not, we'll have to go into confidential session and pull up the confidential version. And neither versions have been admitted into evidence yet.
That it disappeared. Mr. Dixon has his hand up. Mr. Dixon, am I phoning a friend? If you have a
With your honor's permission, this exhibit has now been admitted as, I believe, under Mr. Neal's revised answer testimony. And it was one of the exhibits, I think it's CN7. I'm working from memory, and I'm an old guy, so I might be wrong. But I think data discovery request UCA 3-8 is now in the record already.
Yeah,
As what? What is the exhibit number?
I believe it's CN. Let me try and pull it up.
I see that it's hearing exhibit 301, attachment CN-7, and that version does have the confidential amounts redacted.
Thank you. That's what I just wanted to clarify for the record, and so we don't admit one that's already admitted, as you requested, not to have double exhibits. And again, part of the reason this was an objected to document, so we listed it in the exhibits as well as on the document. And I'll be quiet.
Okay, why don't we pull up the version that's been admitted into evidence, the public version? And on our exhibit list, it's identified as hearing exhibit 301, attachment CN-7. And it does say public later on. It does look like it's marked correctly. Both that and the confidential version both look like they've been marked correctly. They're just the way they were filed, they weren't marked consistent with the title. Do we have that up? Let's see. Yep. Okay. Mr. Dixon, do you have something else? You still have your hand raised.
I'm going to guess not and just carry on.
Yeah.
Sorry, no, I was trying to hit mute. Note, I'm trying to lower my hand. Sorry.
Mr. Schultz, the company was asked questions in discovery regarding the cost of curtailing energy in 2023, correct?
Correct.
And Mr. Neal, in his answer testimony, you recall from your review of it, had provided a proxy number because this information hadn't been included in the company's direct case. And then later, when got the response, revised that answer testimony to include this data. Is that correct?
That sounds reasonable. I would have to actually look through to make sure that what you described is in fact the case, but yes, that sounds correct.
Okay. And so in order to have a full picture of the cost to curtail, UCA had to ask in discovery for the company to provide this information, correct?
Objection calls for speculation as to what's in the entire direct case. I'd also note that they have the discovery response. It's in evidence. It's been included in Mr. Neal's testimony. So this is in evidence. I don't know what the issue is.
Yeah, sustained.
Okay, I can move on. And I'm just looking at some of my questions, and I think in an abundance of caution, it might make sense to go back to a highly confidential. If you could give me just a moment, I can see if there's a way to sort of shift this chapter.
Okay, yeah, just go ahead and take your moment.
While we have a moment, would I be able to just do a mic check here? I think I figured out what the problem is with my audio. I'm gonna put, I think the microphone is different than where I thought it was. Can you hear me now or now?
Yes.
There's a difference between those? Or was the audio okay both times?
I can just hear you now. I'm not sure.
Okay.
What angle.
There are two locations where I am where the microphone could be located, and I had my arm up on the desk and it might have been blocking the microphone in one of those cases. I'm trying to figure out what's happening with the audio.
I see. Thank you. Jorn, I think it would just make sense to go into a brief, highly confidential session.
Okay, we will move into highly confidential session. Casey, if you could just let us know when we're off the webcast and ready to begin highly confidential session.
Yes, and I don't think anybody else has joined, but if public service attorneys can just give the participant list a quick look and make sure there's nobody here that shouldn't be.
All good, Casey.
Thank you.
Jorn, I think I have probably about 20 minutes left.
Okay, thank you.
And-
Casey, are we back?
Yep, we're ready to go now.
Okay, we will, now you can go ahead and start when you're ready. I'll just note for the record that we're back into a public session, and this is the continued cross-examination of Mr. Schultz.
Mr. Schultz, in your rebuttal testimony, you discussed what you characterize as valid reasons for CTs to be running during times when renewable energy was curtailed, correct?
Correct.
Okay. And if we could just pull up hearing exhibit 108 at page 9.
Sorry, so you don't need CN5 anymore?
I will in a moment.
Okay.
And if we go to page 9. And here, Mr. Schultz, you detail, and this is in rebuttal testimony, you detail some of these reasons that you believe are valid reasons why CTs may be running during times renewable energy is curtailed, correct?
Correct.
And you give examples that CTs may need to be run to maintain a balance of power, correct?
Yes.
Or because of renewable volatility,
Yes.
or reasons unrelated to economic dispatch, such as mandatory testing or transmission support, correct?
Correct.
Okay, and then if we could go to CN5.
Get the full name of that exhibit on the record.
Hearing exhibit 301, attachment CN5.
Thank you.
And these valid reasons, these are things that help give the full picture of the company's generation decisions, correct?
Yes.
Okay. And so if we could just scroll down this discovery question, and if we could just scroll down to the bottom. And Mr. Schultz, you're the sponsor of this discovery response, correct?
Correct.
And if we could just go up to the top and look at question B. And here, UCA had asked the company to identify each hour in table CN1 and CN2 where startup costs and marginal costs required a CT to be run while renewable energy was curtailed or while Cabin Creek was being pumped, correct?
That is the question, yes.
Okay, and then if we can just scroll down to the response. And here is where you indicate that from your perspective, the company can't do this full analysis for each of the 90 instances identified by Mr. Neal, but as a courtesy, we'll evaluate the top 4 from each of those charts. So 8 total instances analyzed. Is that right?
Objection. It misstates what's in the discovery response. It doesn't say that the company can't do this. I'd also object on the grounds of relevance, as this has been extensively litigated in 2 motions to compel. And I also need to make a record that this question was previously served at an earlier date in UCCA Set 3, which the company answered on October 31, 2024. And that's not in the record in this case, but it was provided in e-filings as attachment 1 to my affidavit, the Eisenberg affidavit, in response to the motion to compel. So to the extent we're going to misread what's on the screen and then make a claim that the company's not answering the questions, there's an extensive record on this.
Let me rephrase. Mr. Schultz, it's here in this response where you indicate that you will do this analysis for these 8 instances we've already discussed, correct?
I'm reading the response right now.
And I'll just, he can answer I have no problem with him answering the question. I'll just note that there was an objection in this discovery response. So just noting the objection for the record. Thank you.
I agree that we did agree in this response to review the top 4 events in each table. Yes.
Okay.
By dollar value.
Sorry?
By dollar value, not literally the top 4 in order, but the top 4 arranged by highest dollar impact of the recommendation.
Okay. And what you indicated in this Part B discovery response is that you would do this analysis with reference to the factors that are discussed in your rebuttal testimony.
Yes.
And about which the UCA is inquiring in these requests, correct?
Yes.
Okay, and so UCA was essentially inquiring about these valid reasons that the company may have had to have this type of generation, correct?
Correct.
And so by conducting the review and applying the factors that you discussed in your rebuttal testimony to the top 4 instances of potential disallowances in CN1 and CN2, you can demonstrate the quote unquote full picture of the company's generation operations, correct?
Objection vague. I think Mr. Schultz has provided extensive testimony on how much time it takes to provide to dig for the full pictures. I'll just reiterate that these questions were covered by the motions to compel and by the company's responses to set 3, which was prior to the motion to compel, that was never followed up on, which again was served on October 31.
I'm going to respond.
Yeah,
in
you
respect-
can respond, but let me just make this clear that a ruling related to a motion to compel is not a ruling related to whether the witness can be asked questions during the evidentiary hearing. They're really 2 different things. And so in an objection on those grounds, I'm just going to say I'm not going to sustain that objection. And if you want to object continually, it needs to be about the question that's being asked today rather than a prior ruling. So Ms. Crampton, you go ahead and respond to the rest of that, because that was just really only one small piece of what Mr. Eisenberg was objecting to.
Well, I was going to say also, my question is about whether this analysis provides the full picture. That's not something that was part of any motion to compel or response or ruling regarding a motion to compel. So I disagree with that characterization. My question was simply to the effect of whether the analysis that Mr. Schultz conducted is something that helps us have the full picture.
Okay, well, with that clarification, that being the question, then I will overrule the objection. And Mr. Schultz, you can answer to the best of your ability.
Okay, could you restate the question to make sure I'm on target with what's being asked?
Sure. And so just kind of, and I'm sort of reading back from the language provided in this response in subsection B, but by applying the factors that you discussed in your rebuttal testimony to the inquiries of these to these instances identified by UCA and the inquiries of UCA, it helps provide a full picture or fuller picture of the company's generation decisions, correct?
I agree. A fuller picture is would be my preference for response words, because the full picture is extremely complicated. And as I mentioned earlier, the person in the chair is digesting far more data than could possibly be introduced in a single discovery response or in a single spreadsheet.
Okay. I'm going to come back to this topic, but I want to pivot for a second and talk about your rebuttal testimony where you talk about an example from ERCOT. Do you recall that part of your testimony?
Yes, I do.
Okay. And you discuss ERCOT as an example, and ERCOT, when we talk about ERCOT, that's the Electric Reliability Council of Texas, correct?
Correct.
And in your testimony, and I think it might be helpful to just pull this up as we move along. So it's hearing exhibit 108 at page 22. And so here, Mr. Schultz, you describe that you were able to pull information regarding ERCOT from publicly available information, correct?
Correct. The information included here is publicly available via the ERCOT market site.
Okay. And I think you provide a citation to that market site in your rebuttal testimony at the bottom of this page, correct?
Yes, I believe so.
And so specifically from this publicly available data, you discuss the specific date of November 11th, 2024, and discuss ERCOT's data for generation mix and energy storage. Is that right?
Yes, that sounds familiar. I'd have to review the exact date, but that, if we could scroll down to the date, I can confirm.
Yeah, if we could scroll down to lines 13 and 14.
Yes, there it is. I see it.
Okay. And then you actually have a figure on the next page. So if we could just go down to that figure, that's figure MGS-RE-1. And this is showing ERCOT's fuel mix and energy storage resources for this particular date, correct?
Correct.
And this is based on the publicly available data from ERCOT on that
Yes.
website you mentioned.
Yes.
Did you make these charts or are these charts from ERCOT?
They are directly from the ERCOT site itself. I did not make those charts, and I would not be able to make them. This is a compilation of data gathered from all market participants by the market itself, and then made public. This chart is exactly as it appears on the site.
Would it be more data points than your attachment MGS-1 HC? Potentially?
I don't know, because I don't know how they assemble the data that goes into that chart. Given the size of the ERCOT market, I would imagine it is more data.
Okay. And from these two charts, you can determine when the grid was using charge energy storage resources, correct?
That's correct.
And you can determine from these charts when the grid was running CTs.
Correct, yes.
And you can also observe periods when energy storage resources were both charging and discharging and providing multiple services to the grid, correct?
Yes.
And from this chart, you were also able to observe that theoretically, increasing solar resources could have been used to further reduce gas generation, but then it appeared to you that that might not be the optimal economic choice for the system given the expected conditions over the course of the day, correct?
I would have to reread that because the way it was just presented to me makes it sound as if dispatching solar higher than it was possible, and I don't believe that to be the case.
Sure, if we could scroll down to page 24, lines 1 through 5. And just let me know when you've had a chance to review that, Mr. Schultz.
Yes, I see the statement, although the increasing solar could have been used to further reduce gas generation, that is an alternative way of saying instead of placing the solar generation into storage, it could be placed onto the grid and used in that moment as opposed to being placed into storage. I now understand the nature of what this statement is indicating, and feel there are multiple ways that you could state this.
Okay, and we don't need to, I'm not trying to belabor this point, but what I'd like to ask is that what this chart from ERCOT that they created and is available on their website shows is the complexity of generation decisions, correct?
That was not my intent in including it in the testimony. I can explain my intent if you'd like.
Will you discuss this as an example of other systems that have the condition of charging energy storage facilities at the same time CTs are running, correct?
Correct.
Okay. And it demonstrates the complexity of scenarios presented in the day-to-day generation dispatch, in this instance for the ERCOT system, correct?
if I may respond by stating this is not intended to represent the complexity. It is, in fact, quite the opposite. It is intended to provide a very simplistic example of when a significant amount of gas-fired generation was running and a complex market solution still saw that the way to economically manage those storage resources was to charge while gas was still running. The reason this example was presented is because it is the opposite of complex.
Okay. And this example that's provided for ERCOT and the chart that demonstrates this was all what was publicly available at that link that you accessed. Is that right?
Yes, that's correct.
Okay. And in your rebuttal, you also cited CAISO,
California
MISO,
Independent System Operator.
MISO,
Yep.
MISO,
Mid-Continent Independent System Operator.
and the SPP Integrated Marketplace were additional examples that you referenced, correct?
Correct.
You didn't provide any charts or data for those systems.
Not in testimony, no.
Okay. And the information displayed by ERCOT that you can look at and interpret and sort of understand as you describe here in your testimony what was happening and what they were doing with generation, you would agree that attachment MGS1-HC in this case is not similarly easy to interpret.
It is displayed differently. It is more granular data than is presented in the ERCOT example. The underlying themes are all still there and could be created by looking at that data.
Okay, but no charts like the one that you put into your testimony.
Yes.
And so you would agree that in discovery, UCA asked the company to explain the complexity of the circumstances that applied that went into the decision-making process for the identified instances in CN1 and CN2 for when the company ran CTs and curtailed, or when the company ran CTs and pumped Cabin Creek, correct?
Can you restate the first part of that? I apologize. I want to make sure I understand the exact wording.
You would agree that in discovery, UCA asked the company to explain the complexities of the circumstances that applied that went into the decision-making process for the instances identified in CN1 and CN2, correct?
Objection vague. If there's a specific discovery response that Mr. Schultz sponsored, I think we could read the language off of the discovery response. It might be easier for him.
I don't know. The question didn't seem very vague to me. Mr. Schultz, do you think you can answer that, or do we need to pull up a discovery document?
I think I can answer it for this portion, Your Honor. I believe that the request from UCA did ask the company to explain some of those complexities, and I believe our response covered that.
And put differently, UCA asked questions in discovery to help understand the complexities, not of ERCOT, MISO, CAISO, or SPP, but rather of this system, correct?
Yes.
And with respect to these other systems cited in your testimony, you did not provide any orders or documentation from their commissions or regulators that approve or deem prudent the decisions made by these other systems, correct?
Objection relevance. This goes well beyond the simple point he was trying to make in his testimony.
Any response?
These were pointed to as examples of why the company's actions in this proceeding are normal, and that other systems do things in a way that is similar. I mean, that was what he indicated in his testimony. So I think it's relevant whether there's any information about determinations of prudence for those other systems that he cited.
Overruled.
Please repeat the question. I apologize.
Sure. With respect to these other systems that you discussed in your testimony, ERCOT, CAISO, MISO, or SPP, you did not provide any orders or documentations from any commission or regulator that approved or deemed prudent the decisions made for these systems, correct?
Correct.
Mr. Schultz, in your rebuttal testimony, you also discuss Piesco's entrance into the SPP Weiss marketplace, and Ms. McCone touched on this a little bit this morning. That entrance happened on April 1st, 2023, correct?
Correct.
And the entry into the SPP Weiss marketplace has impacted the company's curtailment decisions because SPP now manages and directs some curtailments on the public service system, correct?
Correct.
And SPP Weiss, as you understand it, uses a methodology, the SCED, SCED, to determine curtailments, correct?
Correct. Security constrained economic dispatch.
And so because these come from SPP and the SCED, these are not decisions that are made by the company, correct?
Correct. SCED is incorporating more information than the company has available to it when calculating a dispatch solution for a larger region than just Piesco service territory.
Okay. But the cost of these curtailment decisions made by SCED and SPP Weiss, these are still passed to the company's ratepayers, correct?
Correct.
In rebuttal, you said that any recommended disallowance after entrance into SPP Weiss on April 23rd should not essentially be entertained because those decisions are outside the company's control, correct?
Correct. The company is required to follow SCED dispatch.
So is it the company's testimony here today that any curtailment decisions made by SPP Weiss on the company's system should not be subject to stakeholder or regulator scrutiny?
Please cite where that is.
This is
that a
not part
question?
of your testimony. I'm asking you.
Oh, okay.
You indicated in testimony that you believe that anything after April 1st entrance are decisions outside the company's control, correct?
Yes, the SCED dispatch solution does certainly include factors that are outside company control. And
Okay.
that dispatch does instruct curtailment on our facilities.
And so is it the company's testimony here today that any curtailment decisions made by SPP Weiss on the company's system should not be subject to stakeholder or regulator scrutiny?
Objection. It's beyond the scope of his testimony. It also calls for a legal conclusion. He's testifying as to what Weiss controls. He doesn't have any testimony as to how this commission, the FERC, would address this. And just to be candid, Mr. Schultz is not the expert on what the company's position would be on those issues.
I'm going to overrule the objection. And Mr. Schultz, you can answer that to the best of your ability.
Yes, as counsel points out, this is outside of my area of expertise. I am happy to provide my operational perspective that we are required to follow SCED dispatch instructions from SPP. That is part of being a participant in this market. And therefore, if we are following our obligations as a market participant, those costs should not be subject to scrutiny.
Thank you. I want to pull up hearing exhibit, what's been admitted is hearing exhibit 303. And before we dive into this, Mr. Schultz, just going back to our discussion earlier of your attachment MGS-1HC, is it fair to say that the attachment in its entirety demonstrates what the company did for each hour of each day of that year?
It demonstrates the data that was requested be included with each annual filing. And if you repeat the question, I'll agree to a portion of it, I believe, but possibly not the entire, just a blanket yes statement, if that makes sense.
I'm not sure it does. Let me just ask it again.
Okay.
Is it fair to say that the attachment shows what the company did for each hour of each day of the year per generation?
It shows what the generators put onto the system. There was far more going on at the company overall than just what's included in that.
Okay, and that maybe gets to my next question, which it doesn't necessarily show the why of each of those data points because there's far more going on.
I agree.
Correct? Okay. In this discovery question, and if we can just scroll down to the bottom, and you're one of the sponsors of this discovery response, correct?
Correct.
If we can scroll up, UCA asks the company, please explain how UCA can evaluate the factors that actually go into the decision-making process, including the instantaneous, hourly, and sub-hourly factors in these decisions if this information is not provided by the company in the proceeding. You see that question?
I do.
Okay, and then if we can scroll down to the response. And here, the company has some suggestions for UCA. The company says UCA can review the company's testimony, attachments, and work papers, correct?
Correct.
And UCA can conduct its own analysis and provide answer testimony, correct?
Yes.
And UCA can evaluate this through the discovery process, correct?
Correct.
You also offered in the response that UCA can retain witnesses with experience or expertise related to the operation of utility electric systems, correct?
Yes.
And that UCA can cross-examine, correct?
Correct.
I want to break down these action points suggested by the company. We've discussed earlier that UCA provided answer testimony that responded to the data points provided in your attachment MGS-1HC, correct?
Yes.
And in that answer testimony, UCA conducted its own analysis and provided charts CN1 and CN2 to reflect its own analysis, correct?
Objection, asked and answered, cumulative.
I think it was a different question, but
Why don't you repeat the question?
in answer testimony, Mr. Neal conducted his own analysis and identified instances of potentially imprudent dispatch, which he detailed in tables CN1 and CN2, correct?
Yes.
And that was based on that information from the data points of MGS-1HC.
Yes.
And so that answer testimony and analysis, that's one of the actions suggested by the company here in this discovery response, correct?
Yes, I agree.
And in response to UCA's answer testimony, the company addressed issues raised by Mr. Neal in his testimony and in his tables, and provided rebuttal testimony of its own that provided rationales for what the company believes are valid reasons to run CTs while curtailing or pumping Cabin Creek, correct?
Correct.
And in response to that portion of the rebuttal testimony, UCA served discovery asking the company to apply the listed reasons to the 90 instances that he had identified in CN1 and CN2, correct?
Correct.
And
I'll
serving
just note-
discovery. Oh,
I just have to know for the record that there were objections to those discovery responses, but the question's fine.
and serving discovery, that was one of the actions suggested by the company here in this discovery response that the UCA could do to evaluate the company's generation decision makings, correct?
Objection relevance. Ms. Crampton is now asking Mr. Schultz how UCA should conduct its case and whether it asks the right discovery questions and so forth. And I don't know what the relevance to any material fact that actually has to be decided in this case about generation is.
Response?
Well, I think it's relevant. This is an admitted exhibit, and it's the company's response of what the company says UCA can do to evaluate the information for the issues of this proceeding. So I certainly think it's relevant to the proceeding. I have not asked the witness how to litigate the case. I believe that was part of Mr. Eisenberg's objection, but I disagree with that characterization. I'm going through the action points discussed by the company in its discovery response.
Yeah, I'm going to overrule the objection. I understand the question to essentially be an attempt to summarize a response that the company gave to a discovery request. And I think that we have that response in the record. It's an admitted exhibit, hearing exhibit 303. But Ms. Crampton, if you have a question about that response, you can certainly ask that. We all know what the response is. It's already in evidence.
Okay, thank you. Just referencing this, the company indicated that UCA could use experts with experience related to the operation of utility electric systems, correct?
Yes.
Mr. Schultz, have you had an opportunity to review Chris Neal's CV prior to your testimony here today?
I have.
Okay. And so you know from that review that Mr. Neal has almost 50 years experience working in the energy and utility universe, correct?
I acknowledge he has worked in the utility industry for per the terms of his qualifications, yes.
Okay. And like you, Mr. Neal obtained a degree in economics.
Yes.
But he also has obtained degrees in mineral engineering and mathematics.
Apparently.
Does that sound right from your review of his CV?
Yes, I did not pay attention to those because I did not see them as relevant, but I would have to, yes.
Okay. And he also obtained an MBA in industrial administration, correct?
Yes, if that's in the qualifications, I have no reason to argue with that.
Okay. And you know from review of Mr. Neal's CV that Mr. Neal has experience with modeling of day-to-day operations of utility electric systems, correct?
Yes.
And you know from your review of his CV that Mr. Neal has published multiple articles and journal publications, trade press articles over the course of his career, correct?
Yes.
And with respect to utility operations, Mr. Neal, along with colleagues, has published 2 articles. One called, quote, Integrated Resource Planning with Renewable Resources, and quote, Modeling Renewable Resources in Integrated Resource Planning for the Resource Planning, and that was published for the National Renewable Energy Laboratory, correct?
I'm not familiar with the content of those, but I see that they have been cited.
Okay, and you don't have any reason to dispute that he was part of the publication?
I have no reason to disagree.
Okay. Is it your testimony that a UCA analyst needs to have operation room experience in order to meaningfully critique the company's operation decisions?
Yes.
Would the same be true for a commission staff or commissioner, either advisors to the commission or commissioners, that they themselves would need to have operation room experience in order to meaningfully critique the company's decision-making?
There's a difference between operational decision-making and policy decision-making. If you are asking me if operations experience is necessary to evaluate the decision-making process used in economic dispatch and dispatch for reliability, then I would say without hesitation, yes, that experience is absolutely necessary to correctly evaluate the prudence of these decisions.
Okay, and so my question was, you had indicated, yes, that's true for UCA analysts. My question is, would the same be true for commission staff or commissioners? Do they need operation room experience in order to evaluate or meaningfully critique the company's decision-making?
Objection, asked and answered. I think he said, well, the record will reflect what he said, but it's the same question.
I'm going to sustain the objection. I think we've gone as far as we can with this.
If I could have just a moment, Your Honor. I'm almost done.
Okay, well, we are at where we would normally take our afternoon break. If you could let us know if you're finished before we take our break, that would be great. But if you need the 15 minutes that we're going to take to figure that out, that's fine too.
We can take our break. I have just a few more minutes, but I didn't realize where we were at, so we can break. That's fine.
Okay, it is 3:02 right now. We will take a 15-minute break and come back into session at 3:17. I'll remind you all the webcast is going to continue to run during our break, so be sure to mute your microphones. Good afternoon. Before we go back on the record, let me just check in with my court reporter. Harriet, are you there and are you ready?
I'm here. And
All right, Ms. Crampton. You can continue your cross-examination. You're going to want to unmute yourself too.
Thank you. Mr. Schultz, I know it's been a long afternoon, just a handful more questions for you. And if we could, I'm sorry, if we could pull up again that hearing exhibit, I believe it was 303. And Mr. Schultz, just to orient you, in this discovery response, the company suggested that UCA can evaluate the company's operation of its system through cross-examination of witnesses and introduction of evidence at a hearing, correct?
Correct.
So Mr. Schultz, you indicated in rebuttal testimony that Cabin Creek may be pumped for non-economic reasons such as testing, correct?
Yes.
Can you here in cross-examination at the hearing provide each instance in table CN2 where CTs were pumping Cabin Creek because Cabin Creek had to be run for testing?
I am gonna object on this, as this was directly covered by the motion to compel. And it's, I mean, it's speculative, it's unduly burdensome. It calls for him to do special studies, which would take 90 times 2, 180 additional hours of his time to go do. So I just, those, it's argumentative as well to the extent it rehashes the motions to compel, but I'll just leave it at that.
I'm going to overrule the objection. And Mr. Schultz can let us know if he can answer the question.
I do not have all instances of Cabin Creek testing or any other generator testing in front of me.
Okay. And so that information will not be part of this record, correct?
I cannot produce it right now, no.
In rebuttal testimony, you stated that CTs may be run for reasons unrelated to economic dispatch, such as for mandatory testing or for local transmission support. Do you recall that part of your testimony?
Yes.
Can you please identify each instance in the calculations provided in tables CN1 and CN2 where CTs and or natural gas fired peaking units were run due to mandatory testing?
Same objection, cumulative. It was the subject of the motion to compel. Ms. Crampton's trying to lay a foundation that my witness somehow can't provide information, and that's because, as it says on the screen, if UCA is suggesting that we're required to discuss specific decisions in each of the 87, 60 hours, that's well beyond the scope of the company's burden in this case.
I understand all of that. I'm going to overrule the objection.
My response will be the same to the question on cabin. I'm unable to provide all instances of testing at this moment in time.
And when we talk about tables CN1 and CN2, those tables did not evaluate all 88,760 hours of the year. They were 90 total instances, correct?
90 instances, some of which covered multiple days. And in each particular instance, it's necessary to look at adjacent hours. So 90 instances equates to far more days of research when it comes to operations than just the 90 events.
Okay. And so can you identify each instance in the calculations from table CN1 and CN2 where CTs were run to provide local transmission support?
I cannot provide all examples. I did identify at least one example in the 8 events that I was able to review prior to this hearing.
Mr. Schultz, you stated in rebuttal testimony that, quote, the company may need to pump Cabin Creek at the same time CTs are operating in order to ensure a full upper reservoir for adequate energy and reserves over future peak periods.
Yes.
You recall that?
I do.
Can you please provide each instance from table CN2 where CTs were pumping Cabin Creek in order to ensure a full upper reservoir?
I'm just going to lodge a standing objection on 403B as to cumulative and time wasting. I think we understand the point Ms. Crampton is making and what the answers from Mr. Schultz are going to be. And if UCA, I mean, I don't know, we've spilt a lot of ink on what's possible for Mr. Schultz to spend his full time his job answering discovery.
I understand that. I'll just say that I don't really see these questions related to how much time it would have taken him to respond to the discovery. I think she's just asking him if he can provide that information with respect, as he sits here today, with respect to those two documents. And if he can't, it's fine and easy and simple to get that on the record. If public service wants to offer, a factual stipulation on that, that is another alternative to kind of getting through it a little bit quicker.
Yeah,
but I leave that to you.
No, I think that's appropriate, Your Honor, because we should move along. I'll just say we objected to discovery on burden and special study grounds, but the company will stipulate that for the many reasons in Mr. Schultz's testimony, why the instances that Ms. Crampton has repeatedly referred to as potentially being imprudent, not imprudent, but potentially imprudent, Mr. Schultz is not going to be able to provide, standing on the stand here today, specific explanations for all those 90 instances in Mr. Neal's table. So for any question she would ask on this line, we'll stipulate to that.
Okay, I will accept that factual stipulation. And Ms. Crampton, if we could move on past those questions designed at getting at that information, then that would be great, because you are in the, I think, beyond 2.5 hour territory here. And we need to get to what we really need to get to so that we can move on.
If I may, I'm just not sure I understand the stipulation. What I was going to offer is if the company would just be willing to stipulate to the admission. I think 303 and 304 are admitted. 305 already exists through an attachment CN5. If the company would be willing to admit to or stipulate to 306 through 322, I think that takes care of this line of questioning.
We're not able to stipulate to the additional discovery. We conferred on this earlier this week and weren't able to reach an agreement.
So then can I just, I'm not totally clear what the company has stipulated to, if you could just repeat that.
I think it was, and Mr. Eisenberg, you can correct me. The way I understand it is a factual stipulation that the company's witness is unable, as he sits here testifying today, to provide the detailed background reasons and operational decisions relating to the incidents identified in CN-1 and CN-2. Is that accurate, Mr. Eisenberg?
That's accurate, subject to the clarification that the company's not admitting that those reasons don't exist. It's just that Mr. Schultz doesn't have them at his fingertips. But I appreciate Your Honor helping to move this along.
Okay, so do you understand that, Ms. Crampton? And I'll just say, if you want to get in exhibits 306 to 322, I think that's a different question. Mr. Eisenberg has objected. So if you want to move to try to get those in, that might be a way of moving forward.
I understand the company's stipulation. I think I can streamline some things here.
Okay, thanks.
Mr. Schultz, I imagine you just heard the discussion.
Yes.
Are you, just so I'm clear, Mr. Neal identified 90 total instances in tables CN1 and CN2, correct?
Yes.
And you provided a discovery response that we've discussed previously that analyzed 8 of those instances.
Correct.
And as you testify here today, you are not able to provide that analysis for the remaining 82 of the 90 instances identified by Mr. Neal.
Correct.
And so that information of the company's decision-making or reasoning for those instances is not part of this record, correct?
Yes. It is
Okay.
routine decision-making that takes place every day, every operating hour of every day. And I cannot document all of those decisions in a forum like this, unfortunately. I would like to if I could.
Okay. And you were asked to in multiple discovery questions by UCA, correct?
Yes.
Okay. And the only ones that were responded to were the 8 that we have previously discussed.
Yes.
And Mr. Schultz, you characterized those 8. I appreciate you saying that you would like to be able to analyze all of these other ones, but can't here today. But in response to, and I'm sorry, this is hearing exhibit 301 CN-5, if we could pull that up, please. And if we could go to the response, please. Here, Mr. Schultz, you characterized those 8 instances that you analyzed not as something that you want to do, but rather that this was something that you did as a courtesy to UCA, correct?
Correct.
Does the company believe it is a courtesy and not a requirement of regulation to explain to the stakeholders and commission the decisions it makes in instances of potential uneconomic dispatch identified?
Objection. Argumentative, calls for legal conclusions, is an attempt to rehash the motions to compel, and I think is frankly trying to cover for the fact that, well, I'll leave it at that.
Any response?
I'm not sure what the last part of the objection was, but
Let's start with responding to it being argumentative, because I tend to agree.
I'm articulating Mr. Schultz's language that he indicated that providing information is a courtesy, and I'm trying to explore what that means. If it's a courtesy and not something that is necessary for meaningful stakeholder engagement and meaningful regulation.
I'm going to sustain the objection as argumentative.
Mr. Schultz, does the company believe that providing the information of those 8 instances to the commission is a courtesy?
Same objection. I think it says on this page, and is in the record, what we did in order to try to provide some information to UCA, which took a long time to do, over objection. And it's argumentative to try to tell Mr. Schultz that somehow means he's saying that we're withholding information from the commission.
Sorry, I have a separate microphone and it was muted. So I am going to sustain it. Let's please move on. Ms. Crampton.
I don't have any further questions. Thank you.
All right, thank you. I do have some questions and hopefully this will go quickly. Bear with me for a moment. So there's been quite a bit of discussion about the discovery disputes and the efforts that the company made to respond to those disputes. And so I want to delve a little bit into what the company did do with respect to the 8 incidents that the company dug into and analyzed. And let me just start by saying I don't know that we need this document I'm going to refer to as part of the evidence, but you can let me know if you think you need it. So you recall you provided an affidavit in response to the UCA's first motion to compel?
Yes, Your Honor.
And do you recall in that affidavit, you said that in looking at those 8 events, you did an hour's worth of research for each event, just as a part of the operational review. Do you recall that?
I do.
Okay. And so that would have been 8 hours total, at least as a part of that operational review. Is that right?
That's correct. On total, it was approximately 8 hours. Each event was variable as each event is unique. But yes, in
Okay.
cumulative, it was about 8 hours.
And I understand that there was other time that you put in. I just want to focus on that effort, that
Okay.
initial effort. So can you tell me what you did as a part of that research?
Yes, the first step was to take a look at the overall operational backdrop that the decision makers were making or that were working with on that particular day while they were making those decisions. And that involves a lot of the data included in the highly confidential attachment, the 8760 file that was included with direct testimony. And my first step was to organize that data in a manner in which I could more quickly review the relevant components of that data to get a general understanding of what the load was, what renewable output was, which generation, especially the less flexible generators, which generators were online, baseload generators, and then how the rest of the system was being, the more flexible generation, how it was being dispatched around that overall scenario. That was step 1.
Okay. And so the document you were just referring to, that's hearing exhibit 102, attachment MGS 1 and 1HC, correct?
Correct.
Okay. So you said that was your initial steps. Did you do anything else as a part of that operational review that counted into that 8 hours?
Yes, I then looked at the forecasted renewable output, particularly during periods when other thermal generation was running for support of the system, potentially for reserves, for example, or in the cases where there were specific concerns pointed out by the UCA, I tried to get definitive answers as to why the generators in question were running during periods where it was perceived to be uneconomic to run those generators. And that included looking at some additional documentation in our logs, looking at the daily unit commit plan, other resource availability information, which is in the daily unit commit plan and is also included in the GADS data, to determine what options were available to those decision makers when it came to managing the dispatchable portfolio. So I did pull in additional data from other sources to be able to determine specific examples of testing and transmission limitations that were impacting dispatch.
Okay, thank you. During cross-examination, I believe it was on cross-examination, you testified that there are potentially thousands of data points that, the person sitting at the operational table would be looking at when making these decisions. Did I summarize that correctly?
Yes, it is a significant amount of data.
So in the analysis that you did perform on those 8 incidents, how or even were you able to account for those potentially thousands of other data points that may have fed into those operational choices?
Not all of those factors. There are certain aspects of dispatch that can only be captured by literally sitting in the chair and being faced with a continuous stream of data. And that data is coming in from the field, variable energy resource output, system frequency, area control error. All of this data is constantly changing, and the operator's challenge is to identify those trends and determine not just where the system is at that moment in time, but where the system will be in 20 minutes once the CT is started, or in an hour or 2 hours from now. And it is truly difficult to gain that feel for all of those factors without watching it literally in real time. And I face the same challenge when I'm reviewing this data.
Okay, so Ms. Crampton asked you a good number of questions about, the company being able to find the information that provides the full picture behind those decisions. After just listening to your clarification just now, I'm just hoping we can kind of tie this together so that I can understand, even when you go back to try to piece together why decisions were made, are you even able to get the full picture as the person within the company that does this?
I am able to get a well-rounded picture. I would not call it the full picture. And in part, that's why we employ experienced operators, because we have to turn over those decisions to individuals on shift 24/7 and trust that they are interpreting the data correctly. We have well-trained operators, they're NERC certified, and their job is to analyze that data minute to minute and make the correct decisions. I, as a manager, am able to look back and help validate that those correct decisions were made. I'm not able to adequately experience the process of making those decisions, as that can only be realized by the person in the chair at the time.
So you mentioned that, the data that the person in the chair is looking at is just constantly changing and they're evaluating it in real time. So when you go back to look at these choices after the fact, then do you see how that data changed over in real time, or do you just get like a moment in time? I'm just trying to get a better sense of what information is even available to you.
Yes, that's a great question. And I am able to pull up through a system called PI, Plant Information. And it does have a historical record of much more granular generator output, system frequency, area control error. And that information is, as much as it is more granular and additional information, when viewed in hindsight, it is interpreted differently than when it is being viewed in real time. So I am able to go back and pull up the historical record for that data. But if you are placing yourself in a situation where system frequency is low and your area control error is low and you're under generating and you don't know where the renewables will be 10 minutes from now, that is a different exercise and a different challenge than if you go back and look at what actually happened over the 10 minutes where the operator is in the chair trying to decide whether committing that next CT is the right decision or not. Hopefully that helps describe. If not, I can adjust my response.
No, that's helpful. And I think, I'll just clue you in where I'm going with all of this. I don't know that anybody has figured this out yet. So here it is. One of the things I've been sort of mulling over is overall the feasibility and practicality of a potential future reporting requirement that could include the type of information that's been largely at dispute here. And that's why I wanted to know better sense of what data is recorded, how is it recorded, and how accessible would it be? So let me get to the punchline then. How feasible would it be for the company to be able to include in, say, ECA reporting requirements, the type of decision-making data that's been at a high level, very high level, that's been at issue in this case, and that's with respect to the motion to compel and the information that's been sought through that.
It certainly has been a topic of discussion, and we have yet to find a comprehensive way to present that much data in a manner where it can be reviewed in the correct context. And I think a lot of that centers around the actions are taken with the expectation of future events lining up in the way that they are forecasted to line up. And for any decision, the realization, the consequences of that decision, whether it be starting a CT or committing a longer lead time generator, the consequences of that decision are not realized until 20 minutes to multiple hours into the future. And if there were a way to actually accurately capture what an operator was thinking when they made that decision for every decision of the hundreds of decisions that gets made each shift, we would like to do that. I have not myself been able to come up with a reasonable way where that data will clearly tell the story.
Okay, thank you. So the next question might be one that I have to ask Harlan Hansen, but I'm going to go ahead and see if you can help me. And if you can't, then you can just let me know. And in case it is helpful, why don't we go ahead and pull up Hearing Exhibit 103, Rev 1, and let's go to page 26. And while we're doing that, let me just sort of introduce what this topic is. So Harlan Hansen's direct testimony provides information on what contributed to lower than estimated performance for the company's communal solar gardens. And one of those contributing factors, which is discussed here on this page 26, Hearing Exhibit 103 at lines, I believe, 3 to 7, is that the software to predict, monitor, and track community solar gardens performance did not account for weather in modeling the forecasted performance. So I'll just say I found that very surprising, and I am wondering what, if anything, the company has done to address this issue. And given that, not accounting for weather and modeling seems just like a piece of low-hanging fruit. So has the company addressed this?
I can respond from a system-wide dispatch perspective that we do monitor the performance of behind-the-meter generation in aggregate, and we see that show up in our load, and we do account for it at the bulk electric system level for all behind-the-meter resources. We do try to forecast that and account for weather impacts. What I can't comment is the impact to any individual facility. And for behind-the-meter resources, when bulk electric system dispatch decisions are being made, we are making those decisions based on the expected performance of the entire portfolio of behind-the-meter resources, not just company controlled assets or company maintained assets. So I can't speak to any individual asset, unfortunately.
Okay, so that I'm understanding correctly, you can't speak to whether the software that's currently being used to predict, monitor, and track the actual performance of the gardens is still not accounting for factors such as weather. You don't know the answer.
I do not know the answer. I believe they are talking about different software than the software used by operators for bulk electric system dispatch.
Okay, I will I will just follow up with Harlan Hansen on that.
Okay.
All right, so there's been, a lot of questions today about the many circumstances under which the company may run combustible turbines, which we've been calling CTs, while at the same time either curtailing renewable resources or pumping at Cabin Creek. I am just, and I also understand that the company, and as you said here today, you don't have all the details on every single incident that's been brought up. It's not what I'm asking. What I am asking, though, is, whether, and if so, how the commission can be assured that one or more of those circumstances existed when the company did simultaneously run CTs and curtailed renewables and ran CTs while pumping Cabin Creek.
The purpose of I believe I understand the question, and please correct me if I'm not providing the correct response here in terms of addressing your question. My attempt to respond to the 8 instances was to clearly demonstrate that the activities during the most impactful events were prudent, and there was sound decision-making applied to the instances where curtailment was taking place while CTs were running and or cabin was pumping. And the review of the most impactful events was intended to demonstrate that the company is taking the appropriate steps and is performing economic dispatch in a prudent manner.
So are you saying that the analysis that the company was able to perform are demonstrative examples out of those 90 incidents where the company those circumstances did exist, and therefore, based on that sampling, the commission should be assured that these relevant circumstances may have existed when those decisions were made? Is that right?
Yes, Your Honor.
Okay. Let's pull up your rebuttal testimony hearing exhibit 108. I just want to see if I can get something clarified in the record. Let me see. Okay, let's go to page 12. I think, why don't we scroll down to the bottom of the page? Okay, that's good. Actually, if we could get lines, let's see, 19 through 21, and then I want to get over onto the, okay. All right, so I'll just let the record reflect. We've got hearing exhibit 108 on the screen, pages 12 to 13, and I've got a couple of questions about some of the testimony that begins on lines 19 and carries over onto page 13 to that first paragraph. So in this part of your testimony, you talk about the impact of the company's membership in the SPP-Ys on decisions to curtail. And you explain that the SPP-Ys does direct the company to curtail, and that the way that I read your testimony, that the company cannot be held responsible for decisions that the SPP-Ys directs in terms of curtailments and associated disallowances. Am I understanding that correctly?
Yes, Your Honor.
Okay. The one thing that struck me that was a little bit confusing is on page 13, line 2, where you say those decisions are not made by the company, thus there is no basis for the UCA's curtailment-related cost disallowances after April 1st because the SCED curtailment actions taken after that date were made by WISE and thus beyond the company's control. I just want to clarify, in this testimony, you don't intend to apply that every curtailment action after April 1st, 2023 was directed by the SPP WISE?
Correct. The SCED, security constrained economic dispatch, dispatch set points are calculated as an economic set point, and the company is required to take curtailment action for reliability reasons, and the SPP WISE market is not intended to cover any reliability related responsibilities. So there are certainly instances in which the company does need to curtail for reliability and NERC compliance that are not covered by the SCED economic dispatch algorithm.
Okay, thank you. And I understand if you don't have the answer to this question, but I'm going to ask it anyway. As you sit here today, do you know how many of those 90 incidents that the UCA has highlighted were, actually, I don't know the total 90 were curtailments, but of the incidents relating to curtailments that the UCA highlighted, do you have any idea how many of those were directed by the SPP WISE?
I do not know the exact number, but SCED dispatch was a component of most of those curtailment events, because part of being a market participant in the WISE market means we offer our variable energy resources up for economic curtailment when it's required. So the events where the only justification to curtail would be in line with a situation like the one I described at Missile Site, where there was just simply too much renewable output at the same point of interconnection. That would be a manual dispatch. Most of the other scenarios would involve some amount of SCED instructed curtailment.
Okay, so if the commission were to require reporting in ECA filings of the incidences of curtailment that were directed by the SPP WISE, is that something that the company could do from a feasible point of view?
I believe that information could be pulled from the market dispatch instructions.
Okay, thanks. All right, just give me one moment. I need to review my notes, but that might be all my questions. All right, Mr. Schultz. That's all I have. I know that you're tired. You've been testifying for a very long time today, but I feel pretty confident that Mr. Eisenberg is going to have some redirect questions for you. So if you hang in there with us for a little bit longer, hopefully we can wrap this up shortly. Mr. Eisenberg, redirect.
Thank you, Your Honor. I will try to be as brief as possible. Just to take a couple of topics that that you just discussed, Mr. Schultz, with Judge Mirbaba. You discussed the WISE and SCED curtailments. Could you just briefly describe how those instructions flow into the company's systems and then are executed by the company, if that makes sense?
Yes, those instructions are essentially dispatch set points that are calculated by the SPP market solution and then telemetered to the PSCO Energy Management System, EMS, and then sent to the individual farms with the intent to curtail. So they typically involve a follow flag instruction, which is an electronic communication to indicate that the farm is needed to start responding to those economic dispatch instructions. And then the megawatt level of desired output is the dispatch instruction itself, which goes to the local controls of each individual renewable facility. And those facilities then respond on automatic generation control, AGC.
So are those computer processes, or is it somebody in the control room doing that manually?
Correct. Those are computer processes. I apologize, I'm getting overly technical here, but these are electronic communications between central dispatch systems. The Weiss SCED solution being a market-wide solution. Those dispatch instructions are sent electronically to the PSCO EMS, which is a complex piece of software that interprets those instructions and sends them out electronically to the individual facilities for curtailment. The vast majority of the time, no human intervention is required if telemetry is up and working.
Thank you. The judge asked you some questions about whether the 8 events we've been talking about all day could be demonstrative examples, and you used the phrase most impactful for the 8 examples that you selected. Could you just clarify what most impactful means?
Largest recommended disallowance.
Thank you. Do you recall some questions from counsel for UCA about the difference between your testimony in the highly confidential live direct session today versus what was provided in discovery on, I believe, December 10th? Do you recall that discussion?
I believe so. I might need to, there were many discussions I might need to hone in on December 10th. Yeah.
That's all right. This will be a high level question. Did you withhold any of the information that you provided today from the discovery response you provided on December 10th?
No, we, upon getting further questions, we investigated each event further, and the hours surrounding the events. And when additional relevant information was discovered, we presented that either through additional response or here today.
Do you recall a discussion with counsel for UCA, Ms. Crampton, regarding whether there are codes in attachment hearing exhibit 102, attachment MGS 1, regarding the reasons why the company, say, curtailed or made some other decision? Do you recall that line of questions?
Yes.
Can you describe just briefly what sort of time it would take to code the 8760 rows in that table with the codes that were discussed?
It would be hard to quantify the exact amount of time because I've never personally attempted to do something like that. One of the challenges with investigating the limited number of events that we did invest significant time in was that there's often multiple reasons for any specific dispatch decision. There can be, for example, a need for ancillary services, a need for energy, a need for a future period that is a non-binary risk. The operators on shift are skilled in managing risk in real time and assessing risks that are not clear. And that makes it difficult to assign. If we're just looking for a single unit for a single hour, the evaluation of what codes should apply to that decision for that single unit for that single hour, it could be multiple reasons. And therefore, the only the only time estimate that I can supply is hundreds of hours. I don't know exactly how many, because I haven't tried it.
Okay, thank you. The both counsel for UCA, Ms. Crampton, and Judge Mirbaba asked you some questions about the discovery process, and there were a number of questions asked about the attachment with the 8 instances. Yeah, which is hearing exhibit 301, attachment CN6HC, Rev 1, you know the attachment I'm referring to.
Yes.
And you recall the questioning about what was provided in discovery or not provided in discovery?
Yes.
Did UCA ask any follow-up questions about that attachment regarding any of the specific instances after you provided it to UCA on December 10th?
No.
I'm gonna object to that question and move to strike. I think that that's beyond the scope of questioning. It's also misleading. UCA has served extensive discovery about the circumstances of CN1 and CN2. The company has objected at every turn to answering those questions or making them part of the record. So I would object to this question, and I would move to strike this response.
Overruled.
Turning briefly to a discussion you had very early on with Ms. Crampton regarding, do you recall some discussion about MGS1 and how there's hourly data and how there's also decision-making done by the company? Could you just describe very briefly the difference between the granularity of what's in MGS1, what type of data the company gets, and the time frame for the company making decisions?
The data in MGS1 is hourly granularity data and provides a high-level overview. As I've described earlier, there are hundreds, if not thousands, of data points that are feeding into the many screens in front of an operator that is informing their decision-making process. And that is difficult to capture in a spreadsheet. There is a significant amount of data that operators are digesting every minute of the hour when making these decisions.
Okay, thank you. Switching topics again on you, there was an exchange about curtailment costs with Ms. Crampton, what was and what was not provided in direct testimony. Do you recall that discussion?
Yes.
Who was the witness who provided volume and causation discussion in direct testimony?
Mr. Tutrell.
And who was the witness who provided monthly cost data in direct testimony?
I'm sorry, the cost data was Tutrell.
Yes, and just so let me start over. So you just said the monthly cost data was provided by Mr. Tutrell, and who was then the witness that provided the volumes of the I guess the megawatt hours of curtailment?
I was the witness who provided the volume data.
And so between those, it wasn't one witness; it was 2 witnesses that provided the data to meet prior settlement agreement requirements.
Correct.
And that was provided in direct testimony.
Yes.
And then do you recall a discussion with counsel for UCA, Ms. Crampton, about a discovery question about a $1 per megawatt hour proxy for curtailments? And that was I'll just summarize, that was a different question asking for a different piece of information, but that was provided in discovery. Is that?
Yes, the information required to calculate or estimate that value was provided during direct testimony.
Do you recall some discussion with counsel for UCA, Ms. Crampton, regarding the ERCOT market and discussion of other organized markets that you provided in your rebuttal testimony?
Yes.
what was your intent in providing that information about ERCOT in your rebuttal testimony?
The intent was to provide a clear illustration that other organized markets that are actually in terms of design and sophistication that are more complex than the Weiss market that we operate in, that those markets still find it economic to operate a significant number of CTs while simultaneously curtailing and or placing energy into storage. The illustration in ERCOT was simply intended to demonstrate how much gas-fired generation, how many CTs were running, while the market solution still found it economic to both curtail at times and inject energy into storage. The charts on the November 11th example are most applicable to the storage portion of that discussion.
Thank you, Mr. Schultz. Mr. Schultz, thank you very much for your patience and time this afternoon. Nothing further, Your Honor. Thank you.
Hey, Mr. Schultz, thank you so much for your testimony. I am sure you are ready to be done, and so at least for the time being, you are excused.
Thank you, Your Honor.
I also just want to let everybody know that I am planning on recessing for the day at 5 o'clock. And we're at about 10 after 4 now. I think we ought to just push forward and try to get done whatever we can. It does look like we are going to be going into tomorrow in terms of the evidence. I would be very surprised if you could all do this in the 52 minutes we have left. But with that, let me turn to, is Ms. Caliendo, are you calling the company's next witness?
Yes, I am.
All right, you can go ahead and do that.
Thank you, Your Honor. Public Service calls Mr. Harlan Hansen.
Good afternoon. I'm Harlan Hansen. Good to see you.
Hi there. Okay, please raise your right hand with me. Do you swear or affirm that the testimony you will give in this case will be the truth?
I do.
Okay, you can put your hand down, state and spell your name for me.
My name is Harlan D. Hansen, and it's spelled H-A-R-L-A-N, last name H-A-N-S-O-N.
Thank you. I want to give you a couple of advisements before we begin your testimony. You are allowed to look at materials or exhibits when you're directed to do so by me or one of the attorneys. You can look at your paper copies if you have them, or electronic copies if you have them. We will also most likely have the document pulled up on the screen so you can refer to that as well if that's just as easy for you. In the course of your testimony, you are not allowed to receive assistance from anybody in how to answer your questions, answer the questions posed to you. And then finally, if you become aware during the course of your testimony that you may have to talk about confidential or highly confidential information when we are in a public session, I'm just going to ask that you please let us know before you answer that question. So do you understand and agree to these advisements?
I do, Your Honor. Thank you.
Okay, thank you. Ms. Caliendo, you may begin.
Thank you, Your Honor. Mr. Hansen, by whom are you employed and in what capacity?
I'm employed by the Public Service Company of Colorado, and my current position is the Regional Vice President of Electrical Generation, which includes all of our generation except for renewable sources.
Thank you. And did you cause to be filed in this proceeding Hearing Exhibit 103, Revision 1, and Hearing Exhibit 109, which are your direct and rebuttal testimonies respectively?
I did.
And as Mr. Hansen's testimony has already been admitted to the record, and I believe ECA has waived their cross of Mr. Hansen, he is available for questions from Your Honor.
Yes, that's correct. The UCA waived cross this morning. So Mr. Hansen, did you hear the questions that I asked your colleague relating to the community solar garden, the company's community gardens, solar gardens?
Yes, I did.
Okay, thank you. All right. And if necessary, we can pull up your written testimony, but let me just ask the question. You can let me know if you can answer it. So in your written testimony, you noted some of the contributing factors to lower than estimated performance for the company's community solar gardens. And one of those contributing factors that you identified was that the software did not account for weather in modeling the forecasted performance. And so I'm just wondering if the company has done anything to address this issue.
So the answer to that question is yes. To the best of my knowledge and my understanding is that we have in 2023 during the course of that revised the software packages to better model the weather impacts or those impacts to our projections for what to expect out of the performance of the community solar gardens that we have. And they continue to get evaluated at the end of every year.
And part of that revision is relating to weather impacts.
That's correct. It's related to how much, I'll say, sun or light is expected.
Okay, and am I understanding correctly that didn't happen until after 2023?
That's correct. It was late in 2023.
Okay. All right. That's really all I needed to know. Thank you. Ms. Caliendo, any redirect?
Very, very briefly, just to correct the record. If we could please see hearing exhibit 103 at page 27, I believe that's Rev 1. And there, starting at line 4 down through line 8. Do you see that testimony there?
I do.
And specifically in line 6, it says in mid-2023, the company completed an advanced site configuration. Is that the update that you were describing?
That's the one I'm referring to, yes.
Okay, and just to confirm that the date that was completed was approximately mid-2023.
Yep, I said it wrapped up before the end of 2023. That's correct.
Thank you. That's all, Your Honor.
All right. Thank you, Mr. Hanson. That will conclude your testimony for now, at least.
Thank you.
Okay, according to my notes, actually, you know what? Two things. I think we've got at least one witness, a company witness left, but there was one other thing that came up earlier today I made note of. I wanted to go back to. Hold on just one second.
And Your Honor, will you do that? I think the last company witness was Mr. Treatrout. We indicated this morning that we believe we had a few questions for him. I was able to get into that with Mr. Schultz, so UCA will waive cross of Mr. Treatrout. So I don't think any party has any questions for him unless Your Honor does.
Okay, well, that's helpful to know. Look, I just found my notes. I think this happened this morning. I did mean to bring it up earlier. During Ms. McCone's cross-examination, there was a question about the total amount that the company is seeking to recover. And he mentioned possibly needing Mr. Knighton to testify because that witness was unable to provide an answer in detail. I am just wondering, this is for my own sake, whether we have an exhibit. I imagine we probably do have an exhibit in the record that has that data, the updated version, the most recent. And so I'm just wondering if the company can point that out. And if we don't have that, we might, and Mr. Knighton knows that information, we might want to get him in here.
Your Honor, I can advise you that Mr. Knighton's exhibit exhibit 104, attachment JRK-1 contains that information you seek.
Okay, thank you.
And it's the $750 million number from this morning is approximately correct. but the exact number is in that attachment I just referenced.
Okay, thank you. I appreciate that. I knew it had to be in here somewhere. I just having help getting that into the record so we all know where to go will be, I think, helpful in the long run. So thank you for that, Mr. Denman.
Sure.
All right, and then just looking at our cross-examination matrix with that, I think that should conclude the company's witness presentations. Do I have that right, Mr. Denman?
Well, the next three witnesses were mine, and if Your Honor has no questions from Mr. Knighton, Mr. Ryan, or Mr. Tetrault, then you're correct.
And I do not.
Okay, well, great. Thank you, Your Honor.
Okay, so are we able to get staff's witness?
I believe so, Your Honor. Ms. O'Neill should be present.
Okay, great. Hi, Miss O'Neill. If you
Good
could
afternoon.
raise your right hand with me. Do you swear or affirm that the testimony you will give in this case will be the truth?
I do.
Okay, you can put your hand down. Please state and spell your name for the record.
My name is Erin O'Neill. It's Erin, E-R-I-N. Last name O'Neill, O''N-E-I-L-L.
All right, I'm just going to run through my witness advisements with you. You are allowed to refer to exhibits when counsel or I direct you to do so, and you're able to look at any paper copies that you have in front of you in those circumstances or electronic copies. But we will most likely have the exhibits up on the screen as well. You are not permitted to receive assistance in how to answer questions that are posed to you during the course of your testimony. And then finally, if you become aware during your testimony that you may need to get into confidential or highly confidential information when we're in a public session, I'm going to need you to please let me know before you answer the question. Do you understand and agree to all of this?
Yes.
Okay, thank you. Mr. Crakes, you can go ahead and introduce your witness.
Good afternoon, Ms. O'Neill. Can you state for the record by whom and in what capacity are you employed?
Yes, I am employed as the Deputy Director of Fixed Utilities for the Public Utilities Commission of Colorado.
And are you the signatory to the settlement agreement between trial staff and Public Service Company of Colorado in this case?
Yes, I am.
And for the record, are you adopting the pre-filed testimony of Nick Bongiardina, which was admitted into the record as Exhibit 400 and its attachments?
Yes, I am.
With that, Your Honor, I don't think anyone has reserved any cross-examination, so Ms. O'Neill is available for your questions.
And my notes also reflect that nobody else has reserved time for cross-examination. So I guess it'll just be me. Ms. O'Neill, as I'm sure you are well aware, in this case, the UCA is seeking disallowances based on instances where the company simultaneously curtailed renewable resources while running CTs and pumped Cabin Creek while running CTs. I am wondering whether staff has similar concerns as the UCA has highlighted on these decisions.
I think it depends a little what you mean by concerns. So I think concerns in the sense of interest in understanding dispatch choices and what would drive a situation where CTs are being dispatched at the same time as energy is curtailed. Yes, we are interested and concerned. I think we found in this proceeding through our investigation that the company had satisfactorily explained the reasons and circumstances that led to that. So I think we are concerned about those sorts of things and the dispatch circumstances, but did not find any basis for imprudence from the company in the manner that it dispatched its system in 2023.
Okay, thank you. Did you hear the questions that I asked Mr. Schultz?
Most of them, yes.
So I'll just kind of tie back into the one that I want to bring to your attention. I had asked him a number of questions sort of relating to what if it's feasible, what the feasibility is of including a reporting requirement in ECA filings that could capture, I guess, the decisions, the reasons behind the types of decisions that have been hotly disputed in this case. And I'm just wondering what staff's thoughts are on such a reporting requirement, whether you think it would be useful, and if so, what that might look like.
Yeah, so I mean, I do think that staff is sympathetic to the company's circumstance of, anything trying to look at hourly 8760 data on an annual basis, and all of the system data that is captured in each of one of those moments is an exhaustive set of information with a lot that goes into it. And so I think there's some balance there of what to require from the company that is meaningful and can help us understand the dispatch decisions, but doesn't create such a huge regulatory burden that there's just millions and millions of data points that frankly neither staff nor UCA really has the ability to go through. So I think I'm not saying that our reporting requirements are perfect, but I think we have worked with the company the last couple of years to develop a set of reporting requirements, including hourly data and sort of overview information that helps us identify where there are problems and where we need to have further discussion and discovery and some back and forth with the company to help us better understand, the circumstances that led to the dispatch that we see. So I'm not saying that everything that could possibly be reported is currently required, but I think that staff found that we were able to try to understand the circumstances on the company's system through the process that we have now. And if I can say too, I think there's, maybe a slight difference in sort of trying to understand every individual hour versus starting with some higher level system information to identify, overarching areas of concern and then sort of focusing in on those things. So I think that's more of staff's approach of sort of looking at from a holistic basis the totality of the dispatch system and how many hours different things were being dispatched to identify problem areas, and then sort of poking and asking discovery about those particulars, as opposed to starting with an entire data set of every possible piece of information that could be looked at for the dispatch of the system.
Okay, thank you. You were just a moment ago talking about the information that you already have access to and how that has been helpful in staff understanding the company's, what feeds into the company's decisions and how the company made decisions. I'm just wondering who has access to that information? What information are you referring to?
Yeah, so I mean, there's kind of two basic sets of information that I was referring to. So a lot of the information is what the company files into its direct case in an ECA Prudence review, and then also as a part of these Prudence review processes, we've worked with the company to have reporting in the actual quarterly ECA tariff filings as well, that help us look at sort of what's forecasted to be dispatched on the system, and then some backward-looking information, as well as major events, must runs on transmission that would potentially impact how the system is operated, and that information comes in as part of exhibits in the ECA quarterly reports. And some of that information is confidential or highly confidential, so staff would automatically have access to that, but UCA might not. But that information could be asked for in the Prudence review process. But that's primarily what we have focused on in the last couple of years of working through these Prudence review proceedings, is sort of reporting in the annual cases, and then what is helpful to us to understand how the system will be dispatched, looking at those quarterly tariff filings.
Okay, thank you. me just double check my notes. That might be everything that I have for you. All right, thank you for bearing with me there. That concludes the questions that I have for you. Any redirect?
No redirect, Your Honor. Thank you.
All right, thank you very much, Ms. O'Neill. I appreciate your patience and your testimony.
Thank you, Your Honor.
Okay, so UCA is up next to call your witness.
Thank you, Your Honor. The UCA calls Mr. Chris Neal to the stand and asks him to be sworn.
Hi there, Mr. Neal. Yes, thank you for raising your right hand with me. Do you swear or affirm that the testimony you will give in this case will be the truth?
Yes, I do.
Okay, you can put your hand down. Please state and spell your name for the record.
My name is Chris Neal, CHRISNEIL.
Okay, I'll just run through these advisements really quick here. You are not permitted to receive assistance from anybody as to how you will answer your questions during the course of the testimony. You can only refer to any exhibits or materials when directed to do so by me or counsel. And when so directed, you are welcome to look at those documents that you might have with you in person. And then finally, if during the course of your testimony, you believe you might need to get into confidential or highly confidential matters when in public session, I'm going to need you to let us know before you answer the question. Do you understand and agree to all of this?
Yes, I do.
Okay, thank you. And Mr. Dixon, I will turn the witness over to you to get started.
Thank you. Good evening, Mr. Neal. You have cause to be prepared what's been identified as hearing exhibit 300 HC, answer testimony of Chris Neal, Rev 1, which has already been admitted into evidence. Is that correct?
Yes.
And you also presented into evidence hearing exhibit 31 HC, surrebuttal testimony of Mr. Chris Neal. Both of these were filed on December 18th of 2024. Is that correct?
Exhibit 301, not 31, but yes, both have been filed in exhibit, a note of mine.
I'm sorry, what was your correction I just did to me?
Hearing exhibit 301.
Oh, thank you. I said something different. Thank you for that correction. With that, Mr. Neal is available for cross-examination.
All right, who is going to be doing Mr. Neal's cross-examination for the company?
Good afternoon, Your Honor. Mr. Larson, or Matt Larson, will be doing the cross-examination.
Okay, you can begin when you're ready.
Thank you. Good evening, Mr. Neal.
Good evening, Mr. Larson.
For the record, my name is Matt Larson. I represent Public Service Company of Colorado. We've met before. It's nice to see you.
Nice to see you.
Your Honor, before we get started, I do potentially have a demonstrative for use. We have that in our box. We were not intending to move that into evidence, but I may call that up at some point during the examination. I just wanted to check before if there's any special steps we need to take ahead of doing that, or if we can just move ahead with it at the appropriate time. I can't hear you, Your Honor.
Sorry. Why don't we deal with it when the time comes, when it's appropriate, and I'll just flag it may also be appropriate to get it admitted into evidence, but that really depends on the nature of the exhibit.
Thank you. Mr. Neal, apologies for the interlude there. I want to start talking about the settlement agreement in this proceeding, which has been marked as hearing exhibit 110 and admitted into evidence. Are you familiar with the settlement agreement in this proceeding?
Only vaguely. It's not, we did not agree to the settlement, so we're not in the settlement. So I'm aware there's one, I'm vaguely aware what's in it, but I'm not real familiar with it.
So, and are you aware that the company filed a motion to approve the settlement agreement on December 6, 2024?
I'll take your word for it.
And are you aware that UCA did not file a response to that motion?
I'll take your word for it.
And UCA did not file any testimony in opposition to that settlement agreement, correct?
That's correct.
And this morning, in the preliminaries, your counsel, Mr. Dixon, made a statement that UCA does not oppose the terms in the settlement agreement, understanding that there are additional things that UCA would like. Did you hear that?
Yes.
And do you agree with that position?
Yes.
And that includes the community solar garden credit value at $140,000 that's on page 2 of hearing exhibit 110.
Yes.
I want to move and talk a little bit about disallowances. Generally, you've testified in numerous ECA, PCCA annual prudence reviews. Isn't that true?
Yes.
And one category of disallowances that has been brought forward in some of those prudence reviews have been generator specific disallowances. So for example, related to a particular wind generator or a particular thermal generator. You agree with that?
Yes.
And those have related to the Rush Creek Wind Project, Comanche 3 coal asset. You agree?
Yeah, or Cherokee 4 was a big one in the past. Yes.
Yeah, Cherokee 4 is a good example of what I would call a unit specific disallowance proposal. You agree with that?
Yes.
Okay. And then there's another category of disallowances that relates to the company's operational decisions for how it commits and dispatches units across its fleet. Isn't that true?
Yes.
And that's the category where your recommendations fall in this proceeding, which relate to operating CTs and curtailing renewables, or operating CTs and pumping Cabin Creek in the same hour, correct?
Yes.
So I want to set aside the generator specific disallowances. We don't have those proposals here. I want to focus on the disallowances related to unit commitment and dispatch, kind of system-wide disallowances. You made a recommendation in last year's ECA and PCCA annual prudence review for a disallowance in that vein. Isn't that true?
Yes.
And that was a $5 million disallowance. Isn't that true?
Yes.
And the commission approved a settlement agreement that did not have that disallowance in it. Isn't that true?
Yes.
And the UCA took no position on the settlement, notwithstanding that disallowance was not included. Isn't that true?
Yes.
And if you can recall, in last year's proceeding, are you aware of whether staff or any other party filed any testimony in support of your $5 million system-wide disallowance?
I don't think they did.
And in this year's prudence review, staff's the only other party. So staff has not filed any testimony indicating that they agree with your $1.9 million disallowance for CT generation and renewable simultaneous operation, or the $1.2 million disallowance for CT generation and pumping at Cabin Creek, correct?
Staff told me they did not look at the hourly data and analyze that.
So
for
staff did not,
disallowances.
I'm sorry, I stepped on you. Apologies. Finish
Sorry.
your answer.
Staff did not develop any hourly disallowances. No.
So staff did not file testimony in support of your disallowances here. Isn't that true?
True.
I want to dig in a little bit more to the specifics associated with your disallowances. The basis of, and I'm going to start with the CT and curtail, or the, excuse me, for purposes of clarity of the record, the combustion turbine operation and the renewable curtailment based disallowances, okay?
Yes,
And the basis for that is your review of a spreadsheet, which is attached to Mr. Schultz's direct testimony, which is hearing exhibit 102, attachment MGS1 HC, correct?
correct.
And I'm going to do my very, very best for us not to go into another highly confidential session throughout this examination. So if we need to, we will, but I'd like to try to avoid it if possible. At a high level, that spreadsheet has rows for every hour of the year in 2023. Is that true?
Correct.
And it has columns for every generation unit in the public service fleet, correct?
Correct.
And also has columns that shows curtailment levels, correct?
Correct.
And to come up with your recommended disallowance in this bucket of disallowances that we're speaking about, the first step that you take is you locate hours where there were non-zero values for combustion turbines, showing they were generating power, and also non-zero values for curtailments, and you pulled those hours out, correct?
Correct.
And then you summed up the total megawatt hour of the lesser value and multiplied that by a cost proxy to come up with the value for that particular instance, right?
Correct.
But then one additional step that you took, and Ms. Crampton and Mr. Schultz spoke about this earlier, if you were around for that cross-examination, was that for hours where it appeared to you that the Plains End or Valmont units were, in your words, quote, helping facilitate renewable generation coming into Denver, end quote, you removed the disallowance recommendation for those hours, right?
Correct.
So I want to set aside for the moment the Plains End and Valmont operations. I think we'll get into that briefly. But at a general level, those are all of the steps in your analysis, correct?
I think he's kind of oversimplifying. That's a very detailed and extensive analysis.
But I want to summarize the key steps that we just walked through. So step one is you find the hours where there's CT generation and renewable curtailment. Step two, you sum up the generation and curtailment. And step three, you multiply that by a number to come up with the disallowance value for that particular instance. That's what we just talked about, isn't that true?
Yes.
So in your analysis, and if it's helpful to pull up your testimony, we can do that, or we can talk to it a little bit. And if we need to, we can pull it up. So you let me know if you need me to pull it up. But in your analysis as to why these events were imprudent, in your testimony, you state, quote, these costs can be reduced or eliminated by stopping or reducing generation at the high cost CTs and stopping or reducing curtailment of renewable generation, end quote. Correct?
Correct.
Now, you filed your answer testimony in this case on October 25, 2024, right?
Yes.
And at that time, did you know specifically for any of the hours listed in table CN1, which is hearing exhibit 300 Rev 1, whether the company could have actually stopped or reduced generation at the combustion turbine units?
Did I specifically know? I could tell that if they reduced the generation from the CTs and reduced curtailment and let the wind flow through, that would have exactly the same amount of capacity in generation. So that was a reasonable approach to take.
But you didn't know for any of the specific hours whether the company could have actually stopped or reduced generation at the specific combustion turbine units included in the disallowance. Isn't that true?
I think I showed they could do that. And if they couldn't do that, that was Piesco's position to show that they could not do that.
But you didn't know at the time you filed your testimony, isn't that right?
I've answered that question.
But you did know that there are certain circumstances in which it'd be reasonable and prudent to run CTs or run combustion turbines and also curtail renewable generation. There are certain circumstances where that's appropriate. Isn't that true?
That's true. I had no information on when that was the situation, however.
Yeah, in fact, in your rebuttal testimony, which is hearing exhibit 301, you acknowledge that there are circumstances where it's reasonable and prudent to run combustion turbines and curtail renewable generation. Isn't that true?
Yes.
So although you knew at the time of your answer testimony, there are circumstances when it might be reasonable and prudent for public service to simultaneously run a combustion turbine and curtail renewables, you didn't know at that time whether any of the circumstances were present in the specific hours for which you recommended a disallowance, correct?
Correct.
So I want to turn back to the issue with respect to Valmont and Plains End that you talked about before. You indicated, and maybe it might be helpful to pull up hearing exhibit 300. Ms. Federico, if you're able to do that.
Are we talking the public or highly confidential?
The public version will be fine.
Thank you.
Thanks for the clarification, Mr. Dixon. If we go down to page 8. And I want to focus on lines 5 to 6. And this is where you denote that you excluded hours where it appeared that the Plains End and Valmont units were helping to facilitate renewable energy generation coming into Denver. You see that?
Yes.
And you did that based on a nomogram that was provided that you have from the company that was attached to your testimony, hearing exhibit 300, attachment CN2, correct?
Well, I knew that yes, we'll just say yes.
Yeah, let's go to page 7, Ms. Federico, if you don't mind. We can go to lines 21, 22. And there, prior to addressing Plains End and Valmont, you point out the company's nomograms, which are attachment CN2 to hearing exhibit 300, correct?
Yes, except I pronounce it a nomogram. Those are NO, nomogram.
I'm gonna work on the phonetics of that as we go forward. So can we pull up, Ms. Federico, hearing exhibit 300, attachment CN2, which is the nomogram? And if we could roll down to what is marked at the top as page 5 of 13. And this states here that Plains End, Valmont, and Spindle Hill are online in what is referred to as the base case to achieve maximum coincident Eastern and Southern generation. Isn't that true?
Yes.
And that's the reason you pulled Plains End and Valmont out when you were calculating your disallowances, was because of this representation of the nomogram. Isn't that true?
Yes.
But you didn't pull out any hours associated with Spindle Hill. Isn't that true?
Yes.
Even though it's listed in the same category there, in the same line with Plains End and Valmont. Correct?
Correct.
So this same, I want to scroll down. This thing does not have line numbers or anything, so apologies. But I want to go to you see that where it says generation found to be neutral, asterisk?
Yes.
So that refers to Fort St. Vrain, Rocky Mountain Energy Center, and Fort Lupton. You see that?
Yes.
And they are found to be neutral in the base case, which is what this slide is showing, correct?
Yes.
And this base case is one hypothetical scenario, right?
It's one scenario.
It's one scenario, and it does not account for all possible configurations of the system. Isn't that true?
It's a base case.
But the base case does not account for all possible configurations of the system, correct?
I don't know what you mean by all possible configurations of the system. It's a base case. It applies to this case.
This case, and there could be many other cases. There could be numerous other cases, correct?
There could be other cases, yes.
Yeah. In fact, if you look at the asterisk there on generation found to be neutral, and then you look at the phrasing that's associated with the asterisk, it says real-time conditions may result in different impacts. Isn't that true?
Yes.
So it's possible that under some conditions, any of the units above could provide transmission support. Isn't that true?
I don't know that you can interpret that from that asterisk statement.
It's possible, though, that they could provide transmission support,
I don't know that they can interpret that.
but you don't know that they wouldn't. Isn't that true?
I don't know you can interpret that either.
In terms of reducing curtailments, those same generators under certain real-time conditions could also help reduce curtailments, correct?
I don't know that you can determine that from this nomogram.
Is it possible?
I don't know. They're on the wrong side of the load. The Plains Inn, Valmont, and Spindle Hill, as Mr. Schultz pointed out, are on the load side, and they counterbalance supply coming in from the east. Fort St. Vrain, Rocky Mountain, and Fort Lupton are not on, let's say, the west side. They're on the east side again, and they do not provide counterflow to generation coming in from the east.
So let's actually flip up to the map, which is page 4 of attachment CN2. So can we scroll up one slide there, Ms. Federico?
Sorry, my mouse got stuck.
Yeah, it's okay. Been there. If you look to the right of the central hub, well, first, Mr. Neal, before you on the screen, we have hearing exhibit 300, attachment CN2, page 4. And do you recognize this as a schematic map of the company's transmission system?
Yes. Could you blow this up a little, please?
Is that sufficient?
That's wonderful. Thank you.
Great. So that'll be helpful for what I want to look at, which is if you look to the right, you see the central hub labeled PSCO there?
Yes.
I'm sorry, I didn't hear you, sir.
Yes.
Okay. And if you go to the right of it, there's a white star with an outline, right? With a kind of an orangish outline, and it's labeled MSST PSCO ATC path. Do you see that?
Oh, all right. Yes.
Okay. And you also see the box labeled MSST. Do you see that?
Yes.
And do you understand that to be the missile site substation?
I believe that's the interpretation of what MSST means.
And missile site substation is important because there are a number of renewable units and specifically wind assets that are on the eastern plains and connect through Gentiles at missile site. Isn't that true?
Yes.
And so coming back to that star that we looked at already, which is MSST PSCO ATC path, Valmont is labeled VALM, and it's to the left of that star. Do you see that?
Yes.
And Fort St. Vrain has the acronym STVRN also to the left of that star. Do you see that?
No, I disagree. We're not looking at the missile site star. We're looking at the PSCO star in the middle, and St. Vrain is directly north of that. It's not to the west of it.
My question to you is from MSST, is STVRN to the left of it?
Yes.
Either to the left or to the right?
To the left.
Okay. Then Fort Lupton's also to the left. Isn't that true?
Yes.
And Fort Lupton, for clarity of record, is FLUP. Do you see that?
Yes.
And blue spruce, which is a little easier, is labeled blue, BLUE. Do you see that?
Yes, but I don't know why blue spruce is located over there. It is clearly on the east side of Denver. So I think that's a schematic issue, but that's not where the plant is located.
You and I can agree, though, that blue spruce on this map, on this schematic, and this nomogram is to the left of MSST. Isn't that right?
Yes.
Suggesting all those units could potentially provide transmission support relating to the MSST PSCO path, correct?
I don't agree with that. That's not what the nomogram says.
So I want to move to let's move to the Cabin Creek related disallowances. And Judge Mirbaba, if we need to cut this off or however you want to handle it as we get down, I don't know exactly how much time we got left. I don't think it's a ton.
There isn't much, but I'd like to just use what we have left. We're at about 4:52 right now, so let's keep going until 5 o'clock.
Okay, thank you, Your Honor. So table CN2, hearing exhibit 300, relates to running CTs and pumping at Cabin Creek, correct?
Correct.
And similar to your analysis for combustion turbines and curtailments, your analysis in this cabin pumping and CT operation category had 3 steps. Step 1, you find the hours where there's CT generation and pumping in cabin. Step 2, you sum up the total. You take the less, in step 3, you take the lesser of, multiply it by the amount of energy at a cost in dollars per megawatt hour, correct?
Correct.
And same as curtailment, you understand there are certain circumstances in which it'd be reasonable and prudent to run combustion turbines and also pump at Cabin Creek. Isn't that true?
Yes, there are certain circumstances when that would be prudent.
Yep, and that's what you said in your server rebuttal testimony. Isn't that true?
Yes.
So again, at the time of your answer testimony, you knew there were circumstances where it might be reasonable and prudent for public service to simultaneously run a CT and pump at Cabin Creek, but you did not know whether any of those circumstances existed in the hours for which you proffered a disallowance. Isn't that true?
Yes.
So with respect to a storage unit like Cabin Creek, are you generally aware that the operator will try to fill up the storage in hours where it can be done relatively cheaply, and then use the energy in storage for generation in hours where the cost would otherwise be relatively expensive if it came from elsewhere? You agree with that proposition?
Yes, that's the point of a storage unit like that.
So to analyze what's going on with the storage unit, right, in terms of whether it's pumping or whether it's discharging, and with Cabin Creek, I think you and I can both agree is a storage unit, correct?
Yes.
But you need to take into account what's happening in the hours surrounding when it's used. Isn't that true?
Yes.
And in particular, you would need to look at what is happening in the hours leading up to the pumping or to generation, as well as the forecast for what was supposed to happen next. Isn't that true?
Yes.
Well, forecasts are just forecasts, right? They're not crystal balls. They're not perfect, correct?
Correct.
So the company could take an action, the company being public service could take an action based on a forecast, and the forecast could ultimately be proved to be incorrect. Isn't that true?
Correct.
But in hindsight, in that situation, it may look like the company made the wrong decision when in reality, they were operating consistent with the forecast and made the best decision based on the best information they knew at the time. Isn't that true?
It's possible.
There was some discussion about the Western Energy Imbalance Service, which is operated by Southwest Power Pool. You familiar with that discussion that occurred today?
Yes.
And you're aware that Public Service Company of Colorado joined the SPP Weiss market on April 1, 2023, right?
Correct.
An SPP uses security constrained economic dispatch, or a SCED is the acronym, algorithm to determine least cost dispatch for units across the footprint, correct?
Yes,
They issue curtailment instructions, they being Southwest Power Pool, Western Energy and Balance Service. Isn't that true?
that's what Mr. Schultz said.
Do you have any reason to disagree with that proposition?
I had not heard it before.
Do you have any reason to believe that Mr. Schultz's testimony is incorrect on that?
Not directly.
So after April 1, 2023, Southwest Power Pool is making determinations in many instances for what units to curtail. Isn't that true?
That's what Mr. Schultz testified.
And you have no reason to dispute that testimony, do you?
Well, I'll point out that he also testified that in certain instances, public service modified or made manual adjustments to the SPP dispatch directions.
We can pull up his testimony if it's helpful to look at that. Would you like to do that?
If you're going to search for his statements where he said they made adjustments to their to SPP, that's fine.
Tell you what, we can move to still staying with the Weiss, still staying with Southwest Power Pool, move to a different topic. In 2022, there was a proceeding about public service. Actually, I do have a follow-up question on that. Related to what Mr. Schultz talked about, the redispatch in those instances was for reliability. Isn't that true?
I believe that's what he said.
Okay, coming back to what I was asking about before. There was a proceeding in 2022 about entering into the Western Energy and Balance Service, correct?
Yes.
And that was proceeding number 24A-0327E.
Yes.
Did you participate in that case, Mr. Neal?
Somewhat. I don't recall that I was a witness in that case.
Did you receive notices in that case? Were you noticed? Were you included in intervention?
I don't recall.
Would it surprise you if you were?
No.
Okay. Are you aware that there was a unanimous comprehensive settlement agreement in that case?
Yes, I believe so.
And UCA joined that settlement. Isn't that true?
Yes.
Now, Your Honor, I want to be respectful of time. I know we're right at 5. Do you want me to finish going through the SPP piece, or how would you like to proceed?
No, I think we should go ahead and stop here. Let me just review my notes, see if there's anything we need to address. I don't think I have anything on my list for things that we need to address before we adjourn, but let me just confirm that.
And Your Honor, one thing while you're doing that, I don't anticipate that we have a ton of cross-examination time left tomorrow morning, just so you're aware.
Okay, that's helpful. And I don't have, Mr. Neal, I have a couple questions for you, but not many. So I think that'll be pretty quick. And I don't, based on my notes, I can't identify anything that we need to address before we go recess our hearing until tomorrow, but I'll just check in with all of you. Are there any issues that we need to address before we recess for the day?
Not from public services perspective, Your Honor.
Your Honor, UCA has nothing to raise at this time.
Okay, and what about staff?
Nothing from staff, Your Honor.
Okay. All right, then we will recess our hearing and we will reconvene tomorrow morning, January 10th at 9 a.m. I believe we're going to be using the same Zoom information, but if that is wrong, I'm sure that I will be corrected. Casey, is that correct, or am I wrong about that?
No, you're right.
Okay. All right. All right. Thank you, everybody. And I will see you in the morning. We are in recess.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.